On this episode of Death Row Stories, a house fire claims the lives of two young boys.
They hated him. They wanted blood.
Someone must be held accountable.
14 years later, the prosecution charges their father with murder.
Daniel Dockerty was a man who could turn his emotions on and off.
But when the state's fire forensics come into question,
what they were selling was just bad science.
cracks in the case come to light.
She said I put an innocent man on death row, and there's nothing I can do about it.
Why they lying? Why they cheating? Because they don't want to admit they did wrong.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
August 24th, 1985 was a quiet night in Philadelphia's Oxford Circle community. But during the overnight hours, a tragedy would awaken the neighborhood.
I'm at my house, and my mom gives me a call, and she's like, Kathy's house is on fire. What do you mean? And she's like, it's on fire. It's gone. The whole house is gone.
Outside the row house stood 25-year-old Daniel Dockerty, frantic. His two young children, Johnny and Danny Jr., were asleep on the second floor. Now, they were trapped.
Daniel's hysterical outside. He's trying to break his way into the house. He's trying to grab a hose.
He grabbed the hose. He's trying to squirt the doorway to get back in. He's trying to squirt where the windows were. But the fire was so hot, if it didn't blow stuff out, it melted it. Nothing's gonna work.
When police arrive on the scene, Daniel is so frantic that the police attempt to restrain him, and they push him down onto the ground. Everyone
comes out. Everybody's, where are the boys? Where are the boys? My mom, she just starts crying. It was bad.
The house belonged to Dockerty's girlfriend, Kathy Schuler, who was at a friend's house nearby.
We got a phone call saying that my house was on fire. We drove back up to the neighborhood and we prayed the whole way up there, prayed the whole way to that street. And I still didn't know. Like, I didn't know that they were there, that they were gone. I didn't know.
Firefighters would discover 4-year-old Danny Jr. and 3-year-old Johnny dead in the bed they shared.
This can't really be real. I was playing with those boys the day before. We were playing. And then you blink and then they're gone. Everything, the whole house was gone.
Outside the house, authorities asked Dockerty his name. His answer caught them by surprise. "My name is Mud, and I should die for what I did."
Within hours of the fire, the police want to talk to Dockerty. He says, "Sure, I'll talk to you." He doesn't ask for an attorney, doesn't refuse to answer their questions. And in fact, one of the officers says to him, "Do you want to waive your right to be silent?" Dockerty says, "I ain't got nothing to be silent about." Dockerty's story is that he went to sleep on the couch. He wakes up, the house is burning. His instinctive reaction is to run outside, and that's what he does. And then flames were too intense. He couldn't get back into the house.
5 days later, police again questioned Dockerty and his girlfriend, Kathy.
They asked me if I would be willing to take the polygraph, and I said yes, because I didn't have anything to hide. I was in there for hours. I mean, hours. You know, good cop, bad cop. They said, have you ever lied to protect someone that you love? Their take on was that I knew he did it, but I was protecting him.
According to police, both Dockerty and Kathy failed their polygraphs, but while there was lingering suspicion of arson, police lacked sufficient evidence to make an arrest. Dockerty and Kathy were released, and the case was closed.
This was a family block, and 2 babies died on this block. Women wanted blood. The men were furious. They wanted him gone.
After the fire, I died. I was mourning my boys day and night, and I basically lived at the cemetery. I was there most of the time. And without my boys, I didn't want to go home.
After the fire, Danny was, needless to say, distraught. It got strained, our relationship got strained. He wasn't drinking for a while, and then he started drinking, and when he started drinking, that's when I stopped seeing him.
I was drinking a lot. That's all I did. I crawled into a bottle, and then I crawled out and started living again. But that wasn't until years later.
3 years after the fire, Dockerty met a new girlfriend, Adrian. They married and had a son.
When Stephen was born, I felt like a man again. He's my world. I spent as much time as I could with him. We did everything together.
My dad was my hero. Even in bad situations, he'd make them into good situations. If it was a rainy day, he had this truck. It was a humongous monster truck. The tires were illegal for city limits, but he didn't care. He'd take us through puddles. Every winter, he'd grab all the kids in the family, go sledding. He made life better for a child.
In 1997, Dockerty's marriage to Stephen's mother, Adrian, ended in a bitter divorce. Not long after, Stephen was confronted by his father's past.
I found out about the age of 3 or 4. It just came up one day. I was playing with fire. My dad called me, and he said, "Do you want to end up just like your brothers?" And that's when I found out that I had 2 dead brothers. I didn't know the whole story, but I knew it would hurt my dad because I seen the emotion in his eyes.
"14 years had passed since the fire, but one day, police appeared at Daniel's door.
I went willingly. They didn't tell me they were locking me up. They just told me, "We got a couple questions." I said, "Okay, no problem."
It was supposed to be his weekend to come grab me, and my mom said he wouldn't be coming to get me anymore. And I got really upset because I didn't quite understand what was going on at the time.
I don't cover courts or law enforcement. I covered this case because my editor came up to me and said, "This guy's been charged 14 years after the crime occurred. Why don't you look into it and see if there's a story there?"
Investigators had received new evidence from someone close to Daniel. Evidence strong enough to charge Daniel with the death penalty.
My ex told them I confessed to her. Her lying and getting me put in prison for a crime I never did and a crime that never was.
When Daniel was arrested, he was in the middle of a custody battle with an ex-wife, Adrian Sussman. She says that Dockerty confessed to her multiple times. So it's that impetus, that statement from her, that drives his arrest.
Daniel's death penalty trial began in September 2000. Judge Renee Hughes presided over the trial and ruled that Daniel's ex-wife would not be allowed to testify.
Daniel Dockerty's defense attorney filed a motion for exercise of spousal privilege. What they used to say in the old case law is pillow talk. What spouses share cannot be brought into the courtroom to be used against that person.
But the prosecution had backup. 2 jailhouse informants who claimed to have spoken with Daniel.
2 men come in and say that Daniel Dockerty confessed to them that he had killed his kids and he was crying in his jail cell every night.
The informant's testimony was incredibly consistent on details that were not in the newspapers. They were in 2 different jails. There was no connection between the 2 of them. There was reason for the jury to credit the testimony that they brought to the table.
For 14 years, Dockerty never confessed to anybody. So he is immediately confessing to 2 people who he never met the minute he's put in jail. That raises a big question in my mind.
Daniel's ex-girlfriend, Kathy, was asked to walk the jury through the events the night of the fire.
It was a Friday, and I was working. I worked at a bingo hall, and Danny was supposed to be in an AA meeting and then go back home. But I got home, and, the girls were still there that babysat, and it was late. So I got mad, found him at the bar that I knew he would be at, and I went in and I told him, get home to your kids.
Before going home, Daniel stopped to visit his first wife and the mother of the boys, Kathleen.
The record established that they had an argument. She said she'd come back the next day to pick up the children.
When Daniel finally got home, he found a note from his girlfriend, Kathy.
I had written a stupid note. I don't even remember writing it, but I told him that I was leaving, and I don't know what else I said in there.
From that point, Daniel Dockerty asserts that he went to sleep on the couch. Commonwealth asserts that Dockerty set 3 points of fire. The house was engulfed. The boys died.
Supposedly, he's so angry with his girlfriend and with his former wife that he sets the fire.
Philadelphia Assistant Fire Marshal John Quinn, a 23-year veteran who investigated the house fire, testified that burn patterns showed the fire had ignited in 3 different places, which proved it had been set intentionally.
Quinn looks like the kind of expert witness you would see on TV, very dignified, authoritative in his speech. Quinn says the fire is set in 3 places: a sofa, a love seat, and under a table. Quinn says the fire is definitely arson. He knows it when he sees it. I didn't question it. This is a public official. This is the guy who investigates fires for a living. I did expect that the defense was going to come back with their own expert witness to nullify his testimony, and that never occurred. Quinn's testimony stood alone as to the cause of the fire.
The defense decided to let Daniel testify on his own behalf. The strategy backfired.
Daniel Dockerty was a man who could turn his emotions on and off and wasn't necessarily consistent.
This is where Dockerty hurts himself in his testimony. He's combative. The assistant district attorney asks him a question, and Dockerty says, wrong, like this is like a game show or something. He's asked, were you angry for being nagged? And Dockerty looks at the jury and says, all women nag. There are 9 women on the jury. There was the moment when Dockerty says, in the first moments of the fire, he has a clear path up the stairs to the children, and he doesn't take it. He runs out the door, and you could see the jury recoil from that.
It was the jury that decided credibility, and ultimately this case turned on credibility.
The trial lasted 4 days, but it took less than 3 hours for the jury to convict Daniel Dockerty of first-degree murder and arson. He was sentenced to death.
When my mom first told me that I wouldn't be seeing my father anymore, my reaction, it was pain, because at the time, my father was my hero. As every little boy looks up to their dad, that's their Superman. Do whatever he can for you. And he was no longer there for me.
I once believed in the justice system. I didn't know more. How can you put an innocent man on death row? I was in a fog. I stayed in my cell. To me, that was it. I was welcoming death.
4 years after being sent to death row for the murder of his 2 sons, Daniel Dockerty found hope in a new team of attorneys who agreed to take on his appeals pro bono.
When we first got the case, there were a number of flags, but certainly the 14-year delay from fire to arrest raised serious questions. It was not until he was in the midst of a custody battle that Daniel's ex-wife, Adrienne, went to police and claimed that Daniel, during their marriage, had confessed on multiple occasions to having set the fire that killed the 2 boys and had done so using accelerant.
The police knew the gasoline had not been used to set this fire because they had tested for the presence of an accelerant and had found no evidence of that.
Certainly, one could imagine that she went to the police in order to try and get leverage or an upper hand in that custody battle.
My dad was gonna go for full custody because my mom had issues with drugs. She was scared she was gonna lose me to my father, so she acted the only way she knew how to act, and that was to take my father out of the picture. After my dad got incarcerated, she became twice as much of an alcoholic and twice as much of a drug addict. And the one day she broke down, she said, "I put an innocent man on death row, and there's nothing I could do about it."
At the time that we got involved in 2004, Adrienne had recanted, and she had told members of the family she didn't believe that Daniel was involved in the fire. She never testified in any proceeding, and she died several years ago of a drug overdose.
While Daniel's ex-wife's accusations had opened the door to his arrest, it was a testimony of Fire Marshal John Quinn that pointed to guilt.
The prosecution had a very experienced public servant in Lieutenant Quinn who testified definitively and persuasively that I can tell from these burn patterns, and I can tell you without doubt that this fire was intentionally set and was set in 3 places.
In preparing Daniel's appeals, the defense reached out to renowned fire investigator John Lentini.
There's maybe, 75,000 suspicious fires every year. That's 75,000 chances to get it wrong. The lawyers who were working pro bono give me a call and see what I could do with the case. John Quinn said he could see 3 points of origin. So I looked at the photographs and I didn't see it. It's supposed to jump out at you. And there's no way that you could say with any credibility that this fire started in more than one place. What they were selling was just bad science. But, they sold it at the top of their lungs.
Lentini had seen this problem before. A long history of faulty fire science had led to a number of questionable verdicts.
Fire investigators are the ones who decide the cause of a fire. But what if everything they've learned about fires and arson is out of date and flat out wrong?
If you go back to 1977, there was a book came out, Arson Investigation, Survey and Assessment. And they listed artifacts that you would see after a set fire. Crazed glass, tiny little spiderweb-like cracks, alligatoring, big shiny char blisters. There were several indicators that people used to determine whether a fire was arson. I used to believe in this stuff. And then in 1991, there was this huge fire in Oakland, California. It burned 3,000 houses in a space of 24 hours. And I looked at it and I said, what an opportunity. Because I've got 3,000 known accidental fires. Now I can go see what an accidental fire looks like. I went out there with 2 colleagues and we went to 50 houses. And we found melted steel, we found melted copper, we found crazed glass. We could have said any one of these fires in isolation, oh, this looks like an arson fire.
In 1992, a committee of experts published a new industry guide for investigating fires. Their report, known as NFPA 921, changed the way fires were investigated. It also fueled controversy.
The fire investigation community collectively had its head explode. They went nuts. They hated the book. They said it was all wrong. around 2000. That's when 921 became generally accepted. But some of them still don't like NFPA 921 because it says what you were doing back in the old days was wrong. Who wants to admit that they've sent an innocent person to prison?
On February 17, 2004, Cameron Todd Willingham was executed by the state of Texas. For Daniel's team, the case was strikingly similar to his own.
Willingham was sentenced to death after he was convicted of setting this house fire, which killed his 3 young daughters.
Willingham, like Daniel, was convicted. After that execution, fire science experts, including John Lentini, took a close look.
The arson investigation found that the original investigators had relied on outdated arson science.
But what I have seen that the fire marshal put forward as evidence of arson is not evidence of arson.
I was trained, it's better to let 10 guilty people go than to convict one innocent person.
With Lentini's fire assessment in hand, Daniel's team filed their appeal in November 2006. Among their arguments was the defense's lack of a fire expert at the original trial. But the biggest claim would be lodged against Daniel's trial judge, Renee Hughes, who was also slated to oversee his appeal.
Judge Hughes, at a hearing, made a statement on the record about Daniel being a vile human being and toasting a house with his children in it. Based on those statements, we did not believe that she could fairly decide the appeal, and that's why we filed a motion for her to be recused.
While Daniel's defense had noted Judge Hughes's comments, the term vile human was nowhere to be found in the transcripts. They accused Judge Hughes of foul play.
I don't know why the statement wasn't in the transcript. I didn't direct a court reporter to do anything. That's not my style. If I say it, it can be repeated. But that hearing was over, and so the court reporter closed the record. Nothing about the way in which I handled this case negatively impacted Daniel Dockerty. The jury didn't know what I thought and doesn't know what I think.
Judge Hughes denied the ineffective assistance of counsel claim, and she denied the motion to recuse. We then were in a position to appeal to the Pennsylvania Supreme Court.
On December 30th, 2013, the Pennsylvania Superior Court removed Judge Hughes from the case. And after 11 years on death row, Daniel was granted a new trial.
We were certainly cautiously optimistic that we would get really a fair hearing at the second trial.
This makes me live. It makes me happy, and that's what keeps the smile on my face.
Second trial. A lot of people were in high hopes that my dad was going to come home.
There is no possible way that he would have ever done this to my brothers because he said that they were his angels.
My heart was broken when they lost my boys. My heart was broken when they locked me up. My heart was broken when they convicted me of a crime I did not do. They disgraced my name. I want my name cleared. Because this is a horrible, horrible thing I'm accused of that I did not do. So I didn't think there was any hope of justice. But yet I had to fight for my sons.
As a reporter, I was really interested in the second trial because I thought the first one left so many unanswered questions. David Fryman and Shannon Farmer were arguing that fire science had evolved and it was fair to take a new look at this evidence.
During Dockerty's first trial, Fire Marshal John Quinn had claimed that burn patterns proved the fire had been set intentionally. After reviewing the same photos, John Lentini, the defense's fire expert, saw another possibility.
This chair is stuffed with plastic foam. The steady heat of a cigarette accidentally dropped between the cushions can create a disaster.
This is from a video called Countdown to Disaster from 1984.
The carpet and other furnishings start to break down into vaporous fuels. Then, within seconds, in a process called flashover, everything in the room erupts into flame. No life survives flashover.
Lentini believed the fire in Daniel's home had reached flashover, fully engulfing the structure. This would explain the burn patterns Quinn had attributed to arson.
Dockerty's story about running out, not being able to get back in, it's consistent with behavior that I've seen in other cases where people said, oh, the fire started and it burned too fast, therefore it must have been accelerated. It's not true. Quinn is, of the old school. And back in the day when he learned his trade, furniture wasn't made out of polyurethane. It was made out of cotton batting and stuff that burned slowly. So he wasn't used to seeing fires that burned very quickly.
Kathy, the ex-girlfriend, had told the police that there were several people who were smoking in the house that night. There was also a kerosene heater that was right next to the sofa.
Doherty was a smoker, he was drunk, and he was asleep on the sofa. I would say that you can't rule out a cigarette as a cause of this fire. It's just not that hard to determine arson, if it really is arson. Find puddles of gasoline in a living room, incendiary devices. But determining the cause of an accidental fire is quite a bit more difficult. Problem when you're trying to send someone to prison is you got to prove that it happened. And you got to prove it beyond a reasonable doubt.
Armed with these new advances, the opening arguments of Daniel Dockerty's second trial began on March 22, 2016. But the man whose testimony had helped convict him, John Quinn, was noticeably absent.
He sent a letter to us making quite clear that he wanted nothing to do with testifying at the second trial, that he understood there had been incalculable advances in fire science over the last 10 years, that he had not kept up with those, and that the best that he could say is the opinions that he gave at the time were his honest opinions at the time.
Despite Quinn's absence, Judge Scott O'Keefe, who presided over Daniel's second trial, allowed Quinn's previous testimony to be read into the record.
They actually have somebody sit in the witness stand and read Lieutenant Quinn's lines. That's how it gets read into the jury. So they're seeing a person basically act as Lieutenant Quinn.
Unable to cross-examine Quinn, Daniel's defense struggled to poke holes in his investigation. And when defense expert John Lentini took the stand to introduce the new advances in fire science, prosecutor Jude Conroy seized the moment.
When Lentini is on the stand, Jude Conroy just attacks, calling him names. He says he's someone who would whore himself out for a consultant's fee, and that he's a liar. And Lentini gets flustered. I don't think he was expecting that kind of aggression.
He yelled. He just screamed at me for the better part of 2 days. They let Jude Conroy just run that courtroom. And he was just awful.
Lentini brought expertise and knowledge, but he seemed unprepared at times, and the prosecution exploited that.
Jude Conroy also called Daniel's ex-girlfriend, Kathy Schuler, to the stand, prompting her to reveal a darker side of Daniel's character.
Danny was abusive. He was physical. He hit me, he blacked my eye, he pulled me by the head of my hair on my knees from one side of the street to the other. And he hurt me. He scared me. And his ex-wife, the mother of the kids, he beat her too.
When Daniel and Kathy were together, you inevitably heard a brawl. And the boys would come out. We'd try and play with them to keep them so they're not paying attention to the yelling. But you always heard screaming. Always.
After I stopped seeing him, he was angry. I didn't go out of the house. I had nightmares. I had visions that he came in the window that's locked and you can't even come in. I had fear. I had a lot of fear.
Despite Daniel's abusive history, when Kathy took the stand, she didn't blame him for the fire or the death of his children.
I knew from the first time that they said he tried to get back at his ex and myself that night. I knew that was a lie. I knew that wasn't his motive. It couldn't have never been his motive because I know how much he loved those boys. I know how much he loved them. He would have never taken that chance.
The emotionally charged trial intensified when the prosecution introduced a graphic image. The bodies of Danny Jr. and Johnny in the bed where they were found.
The prosecution was allowed to introduce one photo, and they blew it up. This is like a poster-sized photograph. It was impossible not to look at it.
I walked out. I didn't want to see my brothers hugging each other burnt, because I know that would have scarred me.
It was horrific. Jurors looked ill, as you would expect.
When we came back in, you could see it in their faces that a lot has changed in their demeanor.
Jude Conroy told the jury that's what this case is about. It's two lost children, and someone must be held accountable, and that person is their father.
The courtroom was quiet. After the jury left, I tried to say I love you to my dad. And as soon as my dad turned around to say I love you back, the judge threatened to kick me out.
The jury would find Daniel guilty of arson and second-degree murder.
Daniel was acquitted of first-degree murder, but the jury found that he intentionally set the fire. The two boys who perished in the fire, Daniel bears responsibility for that act.
Judge O'Keefe sentenced Daniel to 2 consecutive life terms. From the bench, he declared, "I haven't seen this despicable a crime in a long time."
As far as we were concerned, Daniel didn't belong in prison, so therefore still facing life in prison wasn't really a victory, and we were focused on trying to get him a new trial.
As Daniel started serving his life sentence, his team appealed, arguing that the photo of Daniel's dead children played on the jury's emotions, and that his history of abuse had nothing to do with the case. 18 months later, in a rare move, the Pennsylvania Superior Court agreed, again overturning Daniel's conviction.
I was amazed that they got a second trial, and to get a third was truly rabbit out of the hat.
I just could not believe that he got the third trial. Could not believe it. I actually had hope for him.
Rather than try the case again, the district attorney offered Daniel a deal.
On the eve of the trial, the district attorney's office offered a non-negotiable plea that Daniel would plead guilty to 1 count of arson and 2 counts of third-degree murder. And it would be called what's called an open plea, which means it would be up to the judge exclusively to decide on the sentence.
Daniel did not accept that deal. I think there may have been a couple reasons for that. One is that he might actually be telling the truth, that he's innocent, and that's what he's always said. The other factor that may have come into play, there was no guarantee that he would get out of prison. He could still be there for life. This just meant that the parole board would consider him for relief.
On March 27, 2019, Daniel returned to court for his third trial. Judge Scott O'Keefe once again presided. But this time, the prosecution would take a different tack.
They were not trying to show that he was trying to kill the children. They were trying to show that he had intentionally set the fire.
Essentially arguing that even if Daniel had no intent that anybody get hurt, that once he intentionally set that fire, game over. He has to live with all the consequences.
The state's key witness, Fire Marshal John Quinn, had passed away years earlier. In his place, prosecutors called on Quinn's colleague, Thomas Schneiders.
Thomas Schneiders essentially reviewed Lieutenant Quinn's report and got up on the stand and rubber-stamped those conclusions and findings and reiterated them. Our view is that that testimony has no scientific basis and so, in fact, should never get to a jury.
National Fire Protection Association writes the rules for the industry. Dozens of courts have held that if you don't follow NFPA 921, you don't get to put your opinion before the jury. I don't know how Mr. Schneiders can say that he followed 921 and agreeing with Quinn that there must have been arson. I think that if they're faced with two competing experts, the jury doesn't have the experience or the knowledge to decide which one of those experts got it right.
One of the things that's frustrating is the willingness of the court to accept the way that things have always been done, even when there is scientific evidence showing that that doesn't really have validity anymore.
If you're looking for doubt, consider the fact that he was not charged until 14 years after the crime. The fact that nobody saw him strike the match. The fact that there was dispute over how the fire actually occurred. All those things I felt could have raised a question in a jury's mind.
The defense wanted to focus on the fire science. They didn't give any weight to the statements of the witnesses who heard Daniel Dockerty admit that he had committed this crime. The jury did.
In April 2019, after a third jury had found him guilty, Daniel Dockerty was about to learn his sentence. In protest, he refused to enter the courtroom. So Judge Scott O'Keefe took his ruling to Daniel.
Judge Scott O'Keefe left the bench and walked over to the doorway, yelling in, "Mr. Dockerty, what you did that night was despicable just to get back at your girlfriend and estranged wife. You burnt your own 2 children to death."
Judge O'Keefe's actions throughout the second and third trials are now at the center of Daniel's appeals.
I knew I wasn't getting a fair trial from when they first locked me up. I have no hope I'll ever get out because they do not want to admit they put an innocent man in prison, let alone on death row.
He's been in prison for 20 years now, since he was arrested in 1999, and he believes that he's been unfairly convicted multiple times. He's had multiple judges who've made statements that were inflammatory and disparaging of him, so he's very frustrated.
The case has ravaged Daniel. He was a young man when he entered prison. Every judge that has heard his case has been overturned, and he continues to maintain his innocence.
I know it's our system. I just hope to God I never, ever, ever have to be judged by a jury of my peers. I hope no one I know does.
It has been said that if you survive a fire that your children die in, you might as well just run back in there and die, because you're going to get blamed for it. And the truth be told, if you're in a courtroom sitting next to a defense attorney, you've got to prove yourself innocent. This innocent till proven guilty, it's a nice thought, but it doesn't obtain very often in American courtrooms.
This case has been tried 3 times, 3 juries of 12. 36 citizens have examined the body of evidence and came to the same conclusion. I think all humans have emotions about the loss of life, but when the victim is a child, it's hard on jurors. The community should rest soundly that Daniel Dockerty was treated fairly.
When Daniel was arrested 14 years after the fire, people were relieved. They wanted him to be guilty. They wanted someone to be guilty. I was ecstatically happy he was going to sit on death row till the day he died. And then I started reading some of the old reports, and some things were questionable. If he's guilty, if he's innocent, I don't know. But when you hear me say that I have questions now about his ability to commit this crime, considering how much I hated him, it's a big deal.
I actually had someone say to me, I don't care if he did it or not, he beat women. He should be where he is. And I can see how a jury would think, here's a man that hits a woman. What kind of man can he be? A loving father.
This one says innocent on death row. This one is for my brothers, Johnny and Danny. On my leg, I have my dad's state number, and I have like a demon holding a cross because I don't agree with our judicial system and the way they screwed over my father.
I keep fighting. I hope one day I'll be able to, well, I can barely walk now, but I would like to walk out of here. At the very least, I would like my sons to carry me out, one way or the other.
On this episode of Death Row Stories, A missing father is found bludgeoned and burned in a Philadelphia cemetery.
We just all felt a horrifying gloom come over us.
And an 18-year-old is sentenced to death.
Terrence Williams is among the worst of the worst.
But on the verge of his execution, a dark secret comes to light.
He begged me not to talk about what he was doing to me.
And when a prosecutor is scrutinized,
my testimony on the stand will have to be my comment.
The clock still ticks against Terrence Williams.
There's a body in the water. He was butchered and murdered. Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
On the evening of June 11th, 1984, 56-year-old Amos Norwood went missing in the quiet Philadelphia neighborhood of Mount Airy.
My mother asked me if I'd seen my father, and I said no. And she said, well, he didn't come home. And I said, what do you mean he didn't come home? So we called his job, and they hadn't heard from him. We started a chain with calling friends and family, and then other church members got involved. Then we filed a complaint with the Philadelphia Police Department about him being missing. We just all felt a horrifying gloom come over us.
On June 14th, 3 days after Norwood went missing, a body was found in a nearby cemetery, bludgeoned and burned beyond recognition.
The body was tied up with his own clothes, and gasoline had been poured on him, and he had been burned. And it took several days for the police to figure out who it was by comparing dental records.
When I was informed that we wouldn't be permitted to view his body, being so disfigured, it left a chill. Why such a violent end to a nonviolent person? My father was loving and caring and spent a lot of time working with other people in his community, mostly young people at church.
A month after the crime, investigators caught a break when someone used Amos Norwood's phone card. The calls eventually led police to an 18-year-old youth named Mark Draper.
Draper was arrested on July 20th, 1984, and he gives a statement to police implicating himself and Terry Williams in the crime. That's when it all started to come crumbling down.
While Draper admitted to participating, he told police that the mastermind of the murder was 18-year-old Terrence Williams. Draper also named Williams for an unsolved homicide that had taken place 4.5 months earlier. Williams's trial began on January 7th, 1986.
The day that I went to court, when they were doing the jury selection, was the first time that I had actually seen Terrence Williams. He was very stone-faced, very angry. He showed zero remorse.
Prosecutor Andrea Fulks sought the death penalty against Terrence Williams. Draper, in exchange for his testimony, got life in prison.
Draper testified that he and Terrence Williams had been gambling on a street corner. They ran out of money. Terry Williams said to him, I know where we can get some money. I know a homosexual guy who lives around the corner. I can extort him. That was the beginning of the whole crime. Terry Williams walks around the corner to a house nearby, and he comes back and says, the guy I was looking for wasn't there.
But then a car pulled up to the boys. It was the man Williams was looking for, Amos Norwood. Williams and Draper got into his car.
Terry Williams says to Mark Draper, listen, we're gonna make some money here. And they drive about a mile. They end up at a cemetery. Mark Draper grabs Amos Norwood from the back. Terry Williams says to Amos Norwood, get on the ground.
Williams and Draper tied Norwood up in his own clothes, took $20, and gagged him with a sock.
They could have stopped at the robbery, but it didn't.
According to Draper, Williams got a socket wrench and a tire iron from the trunk of Norwood's car.
Williams starts hitting Norwood over the head with a tire iron, repeatedly. And he says to Draper, you have to do this too. You're part of this. They take turns hitting Norwood over the head until he stops moving, and there's a ton of blood. They drag the body and dump it between two tombstones. And they drive away in the dead man's car.
A friend of Terrence Williams, Ronald Rucker, also took the stand and testified that later that night, Williams showed up at a house party.
Williams arrives in Center City, Philadelphia. He's nervous, he's agitated. Rucker says, what's wrong? Williams says, I just offed a guy named Amos. And Williams says that he's worried about whether there's evidence left at the crime scene and he's gonna go back and burn the body. He pours gasoline all over the body and he lights it on fire.
The next day, Williams, Draper, and Rucker headed for Atlantic City with Norwood's credit and phone cards.
They're trying to get cash advances out of Norwood's credit card. They're making calls off of Norwood's AT&T card. Williams got $200 cash advance and buys 2 gold chains.
But when Terrence Williams took the stand, he maintained his innocence.
Terrence Williams testified that he didn't kill Amos Norwood. He said that the crime was committed by Mark Draper and someone named Michael Hopkins, who was conveniently dead.
I wanted him to just say, I'm sorry, I'm guilty. If I could have just screamed and screamed stop, I probably would have. I just could bear no more.
The jury didn't believe Williams' story. On February 4th, 1986, they sentenced him to death.
It was not surprising that the jury returned with a death sentence. Terrence Williams is among the worst of the worst.
You don't even think it's real until the sheriffs bring you back up to the holding cells, and so many things be racing through your mind. What's next? What is going to happen to me? Where am I going to go? Just something that you just can't believe happened to you. I was the youngest person on Pennsylvania's death row. I was 19 and getting ready to turn 20. Being able to just get through the day was a challenge. Am I going to survive this place? No, not from the death penalty, but mentally and physically.
In February 1986, Terrence Williams was placed in solitary confinement on Pennsylvania's death row. His path, from a childhood in Mount Airy, caught many by surprise.
I lived a few blocks away from Terry Williams. I met him in first grade, and we became like besties. We walked home from school every day together. He was athletic, and he was smart. Everybody talked about Terry.
At the time of Amos Norwood's murder, Terry was a college freshman and a celebrated former high school quarterback.
The sports culture was really big, and football was the biggest. And it really felt really good, but I was never the type of player that, was a braggadocious or anything like that. That was a really good time in my life.
He got a football scholarship, and I was proud. I was so proud. Oh my God. He came to my house, and I told him, Terry, you have the world in your hands. Please do something with this.
The football field was a very important way of getting out of a house that was always filled with some type of tension. That's where I went to for my comfort. My mom was a very aggressive woman. If she got mad at you, she would exact her punishment right then and there. When she beat me and my brother and my sister, she beat us with extension cords, switches. But once that is over, you had no other choice but to seek her for consolation as well. She was all I had.
Every time she beat him, I never saw him cry. He held everything in. The first time I tried to console him, he pushed me away, but I knew he needed me there.
I was too ashamed to talk about what was going on with me. It was just too difficult because I was made to feel that it was my fault.
Terry deserved for someone to help him early when this stuff was going on, and things may have not gotten to this point, He deserved a chance, and he did not have a chance at hell.
When I first met Terry, I was very much taken with him. Terry is an extraordinarily likable fellow. He's very smart, very articulate. He's well-read. What would make someone act out in such a horrible way? And that was our job as lawyers, to try to answer that question.
When Michael Wiseman became Terry's public defender in 1995, he was surprised to learn that Terry's original attorney had not presented the full details of his life to the jury.
The presentation was what we call good guy mitigation. Terry Williams was a football star. He was, a handsome young man. He was smart. But that's not a substitute for the trauma history that was evident in Terry's life. It's counsel's job to present that to a jury.
Buried in Terry's case file was a psychiatric report that his attorney also never brought up at trial.
Terry had what was known as a brief psychotic break. And that was witnessed by the court's expert at the time of the original trial. And, to my mind, that was powerful evidence.
Wiseman ordered 2 psychiatric evaluations of Terry.
Dr. Fleming told us that Terry was a severely disturbed young man. Dr. Kaufman found that Terry's ability to basically conform to the rules of society was substantially impaired as a result of his trauma.
At a 1998 hearing, Wiseman presented these new findings, arguing that with Terry's history of abuse, he should never have received the death penalty.
We had a very strong case. I still recall his mother testifying that I beat him like Muhammad Ali. It's a quote that stayed with me.
But the state questioned these revelations.
Originally, we got a presentation from Terry Williams and his family that was exactly the opposite. That he was a stable kid, a good kid with a very strong family, strong community ties. And now when he says, actually, my family life was empty and traumatic and abusive, it's hard to square that with the story he already told.
The problem was that at his initial trial, Terry took the witness stand and lied, saying, I wasn't there.
I was young. At that time, I was trying to do my best to save my freedom and my life. I was trying to be a man when I was really just a child.
Unfortunately, the court saw him more as a sociopath, someone who would just lie to get over.
Someone who lights another person's body on fire after beating them over the head with a tire iron is not well. They're sick. The question is whether or not that sickness is a reason not to execute them. I think that's a difficult argument.
The state prevailed, and the judge upheld Terry's death sentence. Wiseman appealed all the way to the state Supreme Court, and then federal courts, without success.
The last paragraph in their opinion, they said, "We know the gravity of this decision." They knew that I was going to get executed. I knew that I had to keep on fighting, stay alive.
With his life hanging in the balance, Terry now came forward with a secret that he'd kept hidden for 28 years.
The reality is that he was the victim of sexual abuse at the hands of the victim. He killed his abuser.
It always makes me feel like it's my fault that I didn't say anything to anybody. And I don't like to feel that. Makes me feel like I'm to blame for what adults did to me as a teenager.
In 2012, Terry Williams was about to become the first man executed in Pennsylvania in 13 years. Federal defender Sean Nolan took over the fight for Terry's life.
I started meeting pretty regularly with Terry. He was very scared, and rightfully so. Pennsylvania had not executed anybody in a long, long time, and they really wanted to.
Looking for evidence that might save Terry, Nolan turned to a man who had refused to talk since the trial, 26 years earlier. Terry's accomplice, Mark Draper.
We told him Terry had recently lost his case in the Third Circuit, that it was moving towards an execution, and he agreed to talk with us. He told us a lot of things that nobody had revealed before in the case.
Draper told Nolan that police had helped shape his testimony, but now he was ready to tell the full story.
They were not going to the cemetery for a robbery. There was supposed to be a sexual encounter, and Terry lost it. And things went badly from there. It was the result of years of sexual abuse by Mr. Norwood.
While Andrea Folks denies it, Draper claims that he told her about this sexual relationship, and she wasn't interested.
And then, even worse, said he was told by the police how to testify that this was a robbery, and not that it was what it actually was. Once Mr. Draper told us about this stuff, Terry started to acknowledge these things, and we started doing some investigation in the neighborhood.
Nolan spoke with the reverend from the church where Norwood volunteered.
We went to see Reverend Poindexter. He told us that there was information out there about Mr. Norwood having, predilections for young boys and things like that. And so we started to get other pieces of this story. We found a man who had been a boy at that time, and he told us about Mr. Norwood propositioning him. That's really when we got to the point where we decided we should bring in a specific expert regarding sexual trauma, and that's why we decided on David Lezak.
I have evaluated about 200 men in capital murder cases. I met with Terry for about a total of 10 hours, and it was it was a level of emotional anguish that you rarely see in another human being.
It was time for me to talk about my pain, my hidden secrets. I felt I couldn't hold on to no more if they were going to execute me.
Terry's entire life was really catastrophic. The first person who abused him was a teenager. Terry was 6 years old.
According to Terry, His teenage neighbor invited him over to play, then raped him. When Terry got home, he told his mother.
I showed her my bleeding from my buttocks, but it was wash up, clean up, and then put your clothes on. The person that you want to confide in most was the person who forbade you from speaking of it again. And that made me feel alone. It made me feel not protected. And it certainly made me fearful even speaking out.
Terry said that by middle school, a teacher began buying gifts for him and his family and raped him numerous times.
Sexual predators see these kids, and they recognize the absence of any kind of love in their life, and they just exploit that.
Terry told Dr. Lisak that when he was 13 years old, Amos Norwood, who was 51, approached him at a local deli.
Norwood propositioned Terry and offered him a substantial amount of money, and Terry finally relented. Very quickly, these sexual encounters became violent. Norwood would whip Terry. Then he would cry and be sort of all contrite and remorseful.
When you're that age, you don't necessarily know how to tell someone to stop hurting you. I thought it was going to be blamed of him not being a part of the church, losing his marriage, losing his friendships. There's times where he begged me not to talk about what he was doing to me.
After 26 years on death row, Terry finally revealed the details of the night that led to the death of Amos Norwood.
I was overwhelmed with fear and anger and rage, and I had enough of it.
On the night of June 10th, Terry met with Norwood in a parking lot, and Norwood anally raped him against the car. It was excruciatingly painful. That rape, I think, was a catalyst.
A tremendous amount of anger, a tremendous amount of hurt, a tremendous amount of shame overtook me the last time he raped me the night before.
What he told me is, as he's striking Norwood on the ground, he is screaming, "This is what you did to me."
I didn't know how to deal with those emotions anymore. I didn't know how to deal with those feelings.
He's finally unleashing the fury that has been bottled up his entire life. The question in Terry's case is it appropriate to execute Terry Williams for murdering a man who raped him repeatedly from the age of 13, including a violent rape the night before the homicide?
Sean Nolan filed a new appeal with Lisak's findings. Meanwhile, Governor Tom Corbett set Terry's execution for October 3rd, 2012.
Attending the death of Mr. Williams wasn't anything that was on my list of priorities. It was very hard, very painful. But how can you say, no, I won't come? I want to see justice served, and I want to represent my father. I cannot say that someone did not sexually assault Terrence Williams, but I will say that I know it was never Amos Norwood.
We really started worrying. We started to speak to the press a good bit around this time because of what was going on with Sandusky in Pennsylvania and what was going on in the Catholic Church scandal in Philadelphia particularly. You know, child sexual abuse in Philadelphia was at the forefront of the news every day.
It's a scandal that won't go away. Catholic priests accused of sexually abusing children.
Jerry Sandusky has been sentenced to prison for the rest of his life.
Penn State football coach Jerry Sandusky had recently been found guilty of 45 counts of child sexual abuse. At the same time, the Philadelphia Catholic Church was embroiled in its own child molestation scandal.
We had people coming out of the woodwork from all different walks of life saying that, Terry should not be executed.
In a last-ditch effort to save Terry's life, Sean Nolan presented the full story of what led to the murder of Amos Norwood in front of the Pennsylvania Parole Board.
We decided to go interview some of the jurors. 5 of them said if they had known what they knew now, they would not have voted for death. We had the widow saying he should not be executed, where she wrote a letter to the clemency board saying that.
When I testified before the clemency board, I made up the name Tammy Williams. If this case was about a girl who had been subjected to the kind of sexual abuse that Terry was, would we not see her as a victim of a succession of predatory men?
But the state argued Terry was a vicious murderer who deserved to die. Chief federal litigator Tom Dolgenos made the case for Terry's execution.
This was an extraordinarily brutal murder, and more than that, it was not his first crime. He had murdered a different man named Herbert Hamilton a few months before.
At the time Mark Draper gave Terry up for the Norwood murder, he also named him for the unsolved killing of 50-year-old Herbert Hamilton, a supporter of local youth sports.
Hamilton was a classic predator. He bought gear for the team, so he was viewed as this nice guy who's doing good things. But it was a pretty thin veneer because he was an intimidating, threatening individual.
According to Terry, he was 17 when Hamilton pressured him into sex for money. One night, an encounter escalated.
He asked Terry to pose for nude photographs, and when Terry refused, it moved very quickly to threats, then erupted into a violent fight between Terry and Hamilton. And Terry killed the perpetrator.
Terry faced trial for Hamilton's murder a year before Norwood and claimed self-defense, but prosecutor Andrea Fulks painted Terry as a prostitute who murdered his John.
The argument that Terry Williams chose to prostitute himself is absurd. Hamilton groomed Terry like all the other predators in Terry's life. This didn't just happen once. This happened over and over and over again, and it happened to a child.
Terry was found guilty of third-degree murder in the Hamilton case, carrying a sentence of up to 27 years.
Where there was more evidence of a sexual relationship, the prosecution was perfectly willing to provide evidence of motive. But in the Norwood case, there wasn't any evidence. Terrence Williams has every incentive to make something up. He's literally trying to save his skin.
The clemency board voted 3-2 in favor of mercy for Terry, but a unanimous vote was required for the governor to act. With Terry Williams's execution just 2 weeks away, new evidence would now come to light.
The prosecution had said that all of the things that we were saying about Mr. Norwood were based on hearsay, but that's not really the case because the evidence was in their own files the entire time.
The execution was so imminent and the possibility was so high. They were asking me where I'm going to send my body and who was responsible for accepting my body, how was it going to be transported. And that was a very, very chilling feeling.
Terry's execution was just days away when a new Philadelphia judge agreed to review his case.
Judge Sarmina ordered the prosecutor's trial file to be brought to her chambers for her to review. And so we felt pretty good about our chances at that point.
Terry Williams would get a new hearing, and only 2 witnesses would be called: accomplice Mark Draper and prosecutor Andrea Fulks.
Fulks was asked about whether she had any inkling that there was a sexual relationship going on, and she acknowledged that she did.
Then it was Mark Draper's turn on the stand.
Mr. Draper testified that he knew that Terry had been in a relationship with Mr. Norwood, and that he was encouraged by the prosecution and the police not to talk about this as a sexual encounter or anything like that. And so the judge decided she wanted to see what was in this police file.
Judge Sarmina ordered all files to be handed over to the court. Terry's defense team would finally see the evidence they'd been fighting to uncover for 26 years.
It was a very bizarre scene. There was a group of prosecutors at one end of the table in this back room. They went through the files first and then passed them down to us. And I think that it was really an aha moment, like, oh my gosh, they have been just concealing this evidence for years, and now here it is right in front of us.
At trial, Andrea Fulks had called Reverend Poindexter to testify that Amos Norwood had been a pillar of the community. But his original statement to police told a different story.
They took a statement that talked about Mr. Norwood being with young boys and things like that, and they took all of that out of his statement. Judge Sarmina used the word sanitized, that this statement was sanitized, and it really was.
In the files, Nolan also found troubling statements from Norwood's widow.
Mamie Norwood talked about some strange encounters that her husband had had. And again, the police sanitized that portion of the statement and turned over a different statement by Ms. Norwood to the defense. The other things that we found in there were handwritten notes that the trial prosecutor had taken, that there might have been some strange things going on with Amos Norwood and sexual encounters.
They're trying to have Terry executed when they have continually hid evidence in this case that certainly would have changed the verdict. They knew that Mr. Norwood was touching little boys. Show that to the jurors, and they're going to say, absolutely not. We would not have voted for death in this case, and that stings to high heaven.
We had been arguing these constitutional violations in that regard for years, and they continued to deny this stuff existed. And here, lo and behold, we found it right in the police file.
Comfortable with the testimony?
I really can't comment on it.
Testimony, you're comfortable with the way you handled the case from the beginning?
What's important is that the record is clear, and that's all I can say.
The evidence the prosecution didn't turn over were a couple of notes about what people had said about Amos Norwood, this kind of gossip. That's not evidence of a sexual relationship.
3 days before the scheduled execution, we went back to court. I mean, the tension was just palpable. I just remember when Judge Sarmina read her order, you could almost feel this exhale in the courtroom. Judge Sarmina ruled the death sentence was unconstitutional because of them withholding evidence, and she also issued a stay of execution at the same time.
I think it would have been much easier down the line if, she had found those notes or whatever and disclosed them to the other side. But do I think it actually affected the justice of the case or the appropriateness of the verdict? I don't.
The state filed an emergency appeal to the Pennsylvania Supreme Court to override Judge Sarmina's ruling. If granted, Terry would die in a matter of hours.
He was scheduled to be executed at 7 o'clock that night. It got to be about 4:15. Me and my 2 colleagues were sitting over in a park next to the courthouse, just kind of not sure what to do at this point. Meanwhile, Terry's execution is less than 3 hours away. The SWAT team had come and they were preparing to move him.
They were waiting outside. They had a van ready that was going to get executed.
I got a call at about 4:30 from a reporter in Philadelphia who said to me, I just got word that the Pennsylvania Supreme Court is going to leave the stay in place. That's how we found out. I found out from a reporter.
Got I just got on the floor and started praying, and started thanking God. Just start thanking so many people that worked hard to get me to that point. But I was still unsure of what the process was from there.
The Pennsylvania Supreme Court temporarily stayed Terry's execution in order to fully review Judge Sarmina's decision, a process led by Chief Justice Ron Castile. But Castile had also been the district attorney at the time of Terry's original trial.
One of the first things we found when we were allowed to go through the district attorney's file was a memo personally signed by Ron Castile saying, "I hereby authorize you to seek death." So we filed a motion for his recusal.
Castile personally denied the motion for his recusal, and 2 years later, presided over the court's unanimous decision.
In December of 2014, the Pennsylvania Supreme Court overturned Judge Sarmina's decision. Terry was back at looking at being executed.
I've been in survival mode, for so many years. But this was something different. It really just broke my heart.
At that point, we were kind of back to the drawing board. Where do we go now? And that's when we decided to try to take this issue up to the United States Supreme Court. And then in October of 2015, they accepted the case.
8 months later, the U.S. Supreme Court ruled on Terry's case. Justice Anthony Kennedy announced their decision.
Whether to ask a jury to end the defendant's life is one of the most serious discretionary decisions a prosecutor can be called upon to make. Nor is there any doubt that Chief Justice Castile had a significant role in this decision. For these and other reasons set forth in the opinion, the judgment of the Supreme Court of Pennsylvania is vacated.
Terry Williams' death sentence was overturned. In December 2017, Terry appeared before Judge Sarmina to learn what his new sentence would be.
It was a full courtroom, lots of supporters, and Terry read a statement that he had prepared that was filled with remorse.
I destroyed my life, and I've destroyed other people's lives who were a part of my family and the victim's family. There's no feeling worse for me to know that I can't take back what I have done.
Terry was resentenced to life at that point by Judge Sarmina. And so finally, he was moved off of death row.
At age 51, after 31 years on death row, Terry Williams began serving life without parole for the murder of Amos Norwood. Sean Nolan and his team continue to fight for a new trial.
When you look back at what happened in this case, it's really astounding, the level of misconduct for many, many years. And, the fact that Terry is now serving a sentence of life without parole based on that is something that needs to be re-examined, I think.
The man that appeared in that courtroom in the 80s is not the same person that appeared at the resentencing hearing. A little side of me feels relieved about that, but I would say I have mixed feelings.
For me, it's okay that Terry Williams isn't going to get the death penalty. I mean, he's being punished severely. He has a life sentence. One unintended consequence, I think, of the death penalties is they tend to make death sentence defendants into martyrs, and one thoughtful reason to be against the death penalty, actually.
There's so much I could say to being on death row and not really believing I was going to get another chance at life. And when it happened, just opened up new possibilities for me, not only for redemption, but to become the man that I want to become. I want to make the best that I can of the life that I have left.
We see in Terry's case such a profound example of you brutalize and torment a child, and there's only so long that that child can contain it. And hopefully, you know, prosecutors, defense attorneys, everybody involved in the criminal justice system will look at how this case sort of ran its course and say, well, let's do better. Let's not let this happen again.
On this episode of Death Row Stories,
all of a sudden I heard some gunshots. They shot the pizza man.
a Louisiana house party ends in murder.
Corey Williams confessed to being the shooter.
He was actively involved in this crime.
When a teenager goes on trial, an aggressive DA pursues the maximum punishment.
To get a jury to kill, you have to transform this child into a monster.
We were at our last straw.
But as evidence emerges, so does the truth.
I remember listening to these tapes completely shocked at what I was hearing.
It ain't gonna be no easy fight.
There's a body in the water. He was butchered and murdered. Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
On January 4th, 1998, pizza delivery man Jarvis Griffin dropped off an order at a house party in the Queensboro neighborhood of Shreveport, Louisiana.
The Queensboro area, it was pretty common that there was some sort of violent crime there. Gunshots, those types of things. The night the crime took place, there was some sort of a party. At some point, decided they wanted to order a pizza. When the pizza delivery person arrived, they decided they were going to rob it.
After handing off the pizza, Jarvis Griffin walked back to his car when he was suddenly attacked.
The bullet went through his lungs and clipped a major artery to his heart, and he died. Well, that's a first-degree murder.
When police got to the scene, they began questioning people who'd been at the house party.
What I need you to do is, in your own words, tell us exactly where you were just prior to all this happening.
It was some people that were hanging outside before anything had happened. And everybody was talking about the pizza man. It was he gonna take some of the price off because he was late. I was in the house when the pizza man arrived. All of a sudden I heard some gunshots. They shot the pizza man.
Among the partygoers, police also questioned two brothers, 20-year-old Nathan and 16-year-old Gabriel Logan. At the station, Nathan pointed to 16-year-old Corey Williams as the shooter.
The story is that Corey is outside, and Gabriel gives Corey a gun. The driver was shot, and Corey ran home. Gabriel moved the driver out of the way, grabbed about $30 and some pizza.
Under questioning, Corey said that Gabriel had shot the driver. But after several hours in custody, Corey's story changed.
Okay, Corey, what I need you to do is tell me what happened
We seen a Pizza Hut, man. And then he said, man, let's get him. Then I walked up to the car. And then I started shooting. And then when I started shooting, he ran over and got the money then.
After Corey Williams confessed, Nathan Logan was released. Gabriel Logan was ultimately charged with second-degree murder. Corey would face the death penalty. Corey's trial began on October 26, 2000. He was represented by attorney Stephen Glassell.
He was 16 at the time. There's evidence to point that maybe he wasn't the trigger man. Maybe it was Gabriel Logan or one of the other witnesses that was not prosecuted by the state. What I do know is that Corey Williams confessed to being the shooter.
Despite Corey being only 16 years old at the time of the crime, legendary Assistant DA Hugo Holland charged him as an adult.
Hugo Holland is an extremely experienced prosecutor. They decided that Corey was guilty of this and should get the death penalty. Hugo really went after him big time.
The state built its case around an eyewitness who'd been outside the party that night, Chris Moore. Moore testified that as delivery man Jarvis Griffin backed his car out of the driveway, Corey Williams approached and began firing. As Griffin lay dying, Gabriel Logan robbed him. Defense attorney Stephen Glassell argued that outside of Chris Moore's testimony and Corey's confession, nothing linked his client to the crime.
There was blood found on Gabriel Logan's shirt. There was testimony that he reached over the pizza driver and got the money bag. The gun was recovered near the Logan residence. And Nathan Logan, his fingerprints were found on the magazine in the gun. We argued that the older kids were pointing the finger at Corey because he was the young kid and they could deflect blame on themselves by pointing to somebody else.
It took the jury just 1 hour to render their verdict. Corey Williams was guilty of first-degree murder.
With the first-degree murder, the jury made the decision on life or death. I didn't think Corey would get the death penalty.
But on October 28, 2000, the jury handed down a death sentence. Corey Williams would become the youngest inmate to enter death row at Louisiana's Angola prison.
I was real small. When I put my head at the head of the bed, half of my feet wouldn't even make it to the center of the mattress. On death row, they don't allow you to be in cells with other prisoners, and you be on lockdown 23 hours in one. I felt like, I wasn't gonna never see my mom and them outside of Angola no more.
Corey grew up the oldest of 4 children in a family struggling with poverty in Shreveport.
Shreveport is actually a pretty big place. There's a lot of poverty. People think that the urban areas of Los Angeles, California are the real jungles of the world. When you look at the real statistics, the murder rate is always higher in Louisiana in places like this.
As an indigent defendant, Corey turned to the Capital Appeals Project to fight his case. Ben Cohen became his attorney.
I got involved in Corey's case in December of 2000. I go up to death row to meet him and expect this sort of fierce, angry person that Holland had described. And he's this child that looks up at you and smiles and wants you to smile back. When Corey was 2, he lived in a house that had 14 people in it. There were roaches and feces and the falling down house next door where the paint chips leak lead into the soil that Corey's playing in. And so Corey's lead levels were horrific.
When I was a little kid, I almost died. I had 2 times the legal amount to kill a full-grown adult.
Lead prevents your brain from growing and developing, especially for young children. And Corey's lead levels likely caused his intellectual disability. Corey had a 68 IQ. That disability causes him to trust people when he shouldn't. It causes him to be naive. People will tell him things, and he will believe them.
As he investigated why Corey would confess to a crime he didn't commit, Ben learned that police had questioned Corey for 6 hours before he finally admitted to the murder.
People with intellectual disability are more likely to falsely confess or be coerced into giving statements that aren't true. The police talked to him throughout the night. He's not eating, he's not drinking. And this is what the police officers do, is they say, we know you've done this. It's that pressure that at some point causes him to say, yes, I did it, now can I go home?
I told him, I didn't do nothing. I don't know what he talking about. I was sleepy, I was disoriented. I really didn't understand what was going on.
What kind of gun is it?
I don't know what kind it is.
What color was it?
Huh?
What color was it?
Black.
Was that same gun you saw a while ago? It was? Your fingerprints on that gun?
Who?
Are your fingerprints on that gun?
And no matter what I said, it wasn't enough. And, eventually I was like, man, whatever, I'm gonna just do whatever it takes just to, go home and lay down. At least I thought I was gonna go home and lay down.
I ain't got to answer no more questions. Come on, I'm tired. I'm ready to go home and lay down.
I don't have any more questions.
We contested the confession in a pretrial motion to suppress. The district court judge denied the motion. It's extremely hard to win one because you have a law enforcement officer up there and judges generally believe their testimony.
Corey's case had unfolded against a national backdrop of harsh law and order policies.
In the 90s, the crack epidemic had gotten to a point where it was a part of American fabric. Violence and violent crime in inner cities was something that was just completely out of control. People were labeled as predators or super predators.
They are not just gangs of kids anymore. They are often the kinds of kids that are called super predators. No conscience, no empathy. We can talk about why they ended up that way, but first we have to bring them to heel.
Blacks must understand and acknowledge the roots of white fear in America. There is a legitimate fear of the violence that is too prevalent in our urban areas. Violence for those white people too often has a black face.
Riding a wave of public anxiety over rising violence, President Clinton signed a new crime bill into law in 1994.
It was the beginning of a real lockdown of America. He came into office, there were like 800,000 people locked up. By the time he left office, there were 2 million people locked up.
In Shreveport, Louisiana's tough-on-crime approach was led by prosecutor Hugo Holland.
I would consider District Attorney Hugo Holland as probably one of the most ferocious legal predators that they have in the state of Louisiana. He had a big portrait on the entrance of the district attorney's office of one of the architects of the Ku Klux Klan. Caddo Parish, per capita, sent more people to death row than any county in the United States of America.
Shreveport was the Confederacy's last stand. It was a part of the country that, Reconstruction never touched. And there has been this sordid violence towards people of color, African Americans, for over 100 years. And so this was where Corey was raised.
At Corey's trial, the prosecution repeatedly referred to Corey as a predator. His defense attorney, Stephen Glassell, never objected.
That term, predator, is dehumanizing and inflammatory and prejudicial. I don't know why I didn't object. I would not consider Corey to be a predator. He was kind of just an immature guy that was a follower and was a tag-along.
To get a jury of 12 unanimous people to kill, you have to transform this child into a monster. Race unquestionably plays this deep, inextricable role in the way that Corey was treated.
As he worked to save Corey's life, appeals attorney Ben Cohen faced a difficult choice about strategy.
Do you focus on the fact that this is a potentially innocent person convicted in circumstances where he should get a new trial? Or do you focus on the fact that he is a 16-year-old with intellectual disability and should be exempt from punishment? It doesn't matter if you're innocent, if you're dead.
Ben's path forward would become clear in 2002, when the U.S. Supreme Court decided a landmark case, Atkins versus Virginia.
By a 6-3 margin, the Supreme Court has ruled that executing the mentally retarded now violates the Constitution's Eighth Amendment ban against cruel and unusual punishment, because, wrote Justice John Paul Stevens, of their disabilities in areas of reasoning, judgment, and control of their impulses.
We file supplemental briefs talking about how Corey is a person with intellectual disability.
In October 2003, the Louisiana courts considered Corey's disability and ultimately agreed to change his sentence to life without parole. But moving off death row brought new challenges. Corey would now be among Angola's notorious general population and without the services of his attorney, Ben Cohen. Although Ben Cohen was no longer his attorney, he continued to follow Corey's case.
It was really hard. Corey would call our office, and there would be times when he would be screaming on the phone because he was so scared or because something had gone wrong. When you're in prison, there's times when you get taken advantage of. There's times when it's not safe. And Corey was vulnerable.
On death row, everybody up there got the same thing in common. Everybody facing lethal injection. Whereas in population, you got thousands of personalities to deal with. You got more freedom, but it come at a high risk.
Angola is the last penal colony in the United States of America. It's 18,000 acres, a little larger than the island of Manhattan. It was previously a slave breeding plantation. They needed a way to keep Negroes not just in their place, but in these fields that they were working. It was known in the 1970s and 80s as the bloodiest prison in America, because of the stabbings, because of the rapes, because of the constant violence. I used to think, man, this is sick. Is this really in the United States of America?
Curtis Davis spent nearly 25 years in Angola for murder before his wrongful conviction was overturned.
When I first came to Angola, it was 1992. In prison, I became a tutor, and I dedicated myself to trying to teach men to read and write.
I met Curtis Davis, a law librarian, and seeing those guys in there fighting for their freedom. If they was willing to sacrifice their time, I signed up.
He just came in with this big old smile. He's like, I've been accused of a crime that I didn't commit, and I want to go home. I know you can help me. I told him that he could come to class. He was there every day because he felt like he had been wronged, and it was that thing that was driving him. He would say, but this is the United States. If you are an innocent person, the truth's supposed to win out. He made me start believing it again, because he believed so much.
9 years after Corey was moved off death row, Capitol Appeals Project Attorney Blythe Taplin took over his case. Blythe turned her attention to eyewitness statements that police recorded the night Jarvis Griffin was murdered.
There was a line, I believe, in a pretrial hearing where defense counsel had said, I believe that there are audio recordings of these witness statements. I'm entitled to them. And the DA at the time said, I've reviewed them, and there's nothing on there that's different than the police reports. And so defense counsel never got access to them at the time of trial. So someone sent a follow-up request saying, we're looking for tapes. And we received responses saying that they couldn't locate the file. They said, it likely was destroyed a long time ago. During the course of all of this, members of Corey's team were getting this overwhelming response from the community that everyone knew what had happened to Corey and everyone knew he didn't commit this crime.
Blythe began searching for witnesses, specifically a man named Patrick Anthony.
Patrick Anthony was not from Shreveport, was just visiting. He was living in Texas at the time, so not many people knew him very well. He was there that night on the scene, clearly had relevant things to say, and he had never been interviewed by defense counsel ever. The district attorney had said that they couldn't locate him. So we set about trying to find him.
Well, I didn't find out about Corey's sentence until, I say probably around 2015. I got a call from Blythe trying to find out exactly what happened. The lawyer was just very persistent.
Had to explain, I represent Corey Williams, and I know it's been, 15 years, but I need to talk to you about that night.
That night, me and Nathan Logan was watching movies, and we decided to order a pizza. Pizza man, and he's explaining, well, I'm sorry, and I ended up getting lost, so that's why I was ended up late. Nathan's brother, Gabriel, said, I ought to jack you for being late. Before we can even sit down and eat the pizza good, I heard gunshots. We walk outside, Gabriel hands Nathan the pistol. Nathan said, I need you to hide this gun for me. And so that's when I actually took the gun, and I ended up wiping off the fingerprints and put it in a chip bag, and then I threw it back on the side of the road. The police said I could be held accountable for this murder. I let them know exactly what happened, where I hid the pistol, and when they let me go, that was the last that I heard anything about the case.
The police told Patrick he would have to return to Louisiana to testify. But after Corey confessed, the request was dropped. The defense never got the chance to question him.
Patrick told his story and was very clear from what he witnessed, what he saw. Corey could not have committed this crime.
Maybe if I was able to let the jury hear my side, the outcome wouldn't have been the same. Because I probably would have been able to say, I seen Gabriel give Nathan the gun. Maybe the prosecution didn't want me to tell that story.
We took a statement from Patrick, and we're going to proceed with that as our biggest sort of piece of evidence to bring to the court to try to get them to reverse Corey's conviction. And then I think it was just a couple days later, the district attorney called and said, you know, you're not going to believe it, but turns out we do have this box of these witness tapes, and you can come up and review it.
Prosecutors claimed the tapes matched written summaries given to the defense. But Corey's team learned otherwise.
Nathan Logan told officers on the night of the crime that he had witnessed the events immediately following the shooting of Jarvis Griffin. He indicated that it was his brother.
So who do you think did it? To me, Gabriel, he had to do it.
But when Gabriel showed up, and y'all met up for the first time after the shooting happened, he had the gun with him.
He had that gun.
Did he have the money bags?
Yes, sir. He had the money bags.
Do you think Gabriel shot him?
Yes, sir.
Comparing that to the summary that the prosecution turned over to the defense at trial is shocking. The summary says that Nathan Logan thought Corey Williams committed the crime. One of the other shocking discrepancies between the summaries and the actual recordings is that the police officers themselves repeatedly suggest that it is these older men who are getting together and framing Corey for this crime.
What I heard was that when they was talking, they said that Corey shot the man.
Sound like to me, y'all all decide y'all gonna blame it on Corey.
None of the police officers' suspicion that Corey is actually innocent in being framed is mentioned in any of the summaries that are turned over to the defense. And you had years and years of concealing the fact that these tapes existed. And that was done by prosecutors who dug their heels in for years.
I remember having just this sadness come over me that what Corey had been saying since he was 16 years old and what his lawyers had been saying for 15 years. There's the detective on the case saying the same thing on the night of the crime, and no one turned that over. And it just, you know, it was infuriating and heartbreaking, and at the same time, you have that moment of like, we've got it. Okay, this is the moment.
In a June 2015 hearing, Blythe argued that this new evidence cast doubt on Corey's confession, and in turn, demanded a retrial.
We thought, we're going to be able to walk Corey out of prison, and we're going to just show this to the DA. There's going to be no question that Corey should go home.
James Stewart was elected Cato Parish District Attorney in 2015 and inherited the case.
The state's perspective was, we have a confession and we have evidence that substantiates that confession. The only ruling you have in this case terms his mental retardation is a ruling that said, for purposes of the death penalty, he was mentally retarded. That's not a ruling on his competence to give a free and voluntary statement.
In October 2015, the appeals court concluded that the recorded eyewitness statements were speculative and therefore inadmissible. Corey's confession was also allowed to stand.
That high from thinking, look at these tapes, they show that Corey's innocent, like nobody else cared. We appeal in 2016. We continue to appeal, and Corey's in prison all of this time. And we keep losing.
By 2018, Corey's state appeals were exhausted. His last chance rested with the highest court in the land and attorney Amir Ali.
On average, 1% of petitions are even reviewed by the Supreme Court. So those were Corey's odds at this time. We're talking about 1 in 100 to even get the Supreme Court's attention. We tell the Supreme Court the Louisiana court's failure to take into account the fact that Corey was intellectually disabled when evaluating the significance of his confession. And the second error is the Louisiana court's conclusion that it did not violate the law to withhold these recordings.
Corey's petition got the attention of 44 former justice officials who wrote to the Supreme Court on his behalf.
When I heard my case going to the Supreme Court, I was very nervous and happy. Man, it's the highest court in land. But I was nervous because it's hard to get your case heard up there. And if I get shot down up there, what else happened?
My first question is, okay, are we right? You have to look to see if there's a significant issue, constitutional issue that you might want to address. And I think that's what happened in Corey Williams. Maybe that was something we needed to look at.
While the Supreme Court considered whether to take Corey's case, District Attorney James Stewart hired former homicide detective Rod Demery to reinvestigate his case.
I think the responsibility is on law enforcement. But I wanted to talk to the investigator who investigated the case. He said, well, he confessed. It's difficult enough to take a confession from someone without any corroborating evidence. It's even more difficult to take a confession from someone who doesn't have a complete understanding of a lot of things. After my interview with Corey, we went back to the DA's office and the DA asked me my opinion. He said, well, we got to figure out what we need to do to make it right.
I met with Corey's defense attorneys several times, and I hate to use this word, but they bugged me to death. I mean, they were sending messages, and they were very passionate. Finally, I was able to look at the case the way I needed to. Although I would agree that he had some level of lesser understanding, he was actively involved in some way in this crime. And he didn't have to be the shooter, but I thought he had some criminal culpability to the point that I would not say he was absolutely innocent.
During these negotiations, we refused to get our hopes up, and it was, Ben, Blythe, and I, in consultation with Corey, cautiously optimistic. The key part of that agreement for our purposes was that Corey would be immediately released from confinement.
I didn't want to retry the case. I took into consideration that he had served enough time to satisfy justice. I wasn't sure that they could win their arguments in front of the Supreme Court. I thought there was enough chance that I was willing to take the plea.
In the spring of 2018, James Stewart offered Corey a choice: plead guilty to manslaughter and leave prison with time served, but give up any right to sue for wrongful conviction.
People didn't wake up with a conscience and decide, what, we're going to try to right this wrong. People woke up with an urgency of self-preservation. It should take a whole lot less than the Supreme Court to motivate someone to find out why this 16-year-old kid with an IQ as low as Corey's is actually in prison.
I was undecided initially about the term of the deal due to the fact that I was innocent, but it was an ending, a nightmare that had been going on, the last 20 years. The night before, I couldn't even sleep. All I was saying was, man, I'm finna be home. I was just thinking in my mind all the stuff, that I'm gonna eat, the stuff that I'm gonna do, stuff that I haven't done. When I was walking out of Angola, I couldn't walk fast enough. I remember the man saying, Corey, slow down, you gotta sign the book. Even when you leave Angola, you gotta sign a logbook validating you leaving.
Corey just had the biggest smile on his face, and he was extraordinary. The first thing he did was just thank everyone for working so hard for him.
The day I got out, I remember a warm reception. It was perfect.
I tell him this all the time, but he is the one that gave us the strength. He is the one who pushed people to keep going. Just watching him and watching everything he went through and how he handled it. Yeah, it's extraordinary.
Now that I'm out, I'm having dreams about being on death row. I'm having dreams about all the years I was in Angola. What I went through in prison still affecting me mentally. You know, I wake up at night, cold sweats. I was in prison 20 years and 4 months altogether.
The average person that's convicted of a felony is not going to be able to work a certain job. Until recently, you weren't allowed to vote. Anywhere worth living is not going to allow a felon to live there.
I'm currently living with my mom. I'm just, starting to put my life together.
What I would want from our police, from our DAs, from our justice system is that it protects the weakest amongst us. And that what they did to Corey was they just picked on the weakest. That's what Hugo Holland did.
In 2012, Hugo Holland was forced to resign after he was caught falsifying federal documents in order to procure a cache of assault rifles. Today, Holland tries cases as a freelancer and remains one of the highest paid prosecutors in Louisiana.
He made about $200,000 last year. He made more than the governor of Louisiana, just prosecuting cases.
As of May 2019, fully half of Holland's death penalty convictions have been overturned. He has never been disciplined for prosecutorial misconduct.
Hugo is an interesting person. That's about all I want to say about him. But he won't be prosecuting any cases in Caddo Parish while I'm DA.
When I first got out of Angola, Blythe took me to the bank and she opened up an account for me. It changed your mindset when you got a bank account. When I got my first check, it made me feel like I'm part of the corporate world. I like to start a small lawn company. I can cut grass real good. Before the summer kick off, I'm gonna be full swing.
On this episode of Death Row Stories,
there were guns everywhere, pointed at us.
You're looking for a murderer. You're not taking any chances.
a witness in a murder is gunned down on a Philadelphia street.
We would make sure whoever did this crime would get what they deserved.
And police close in on a likely suspect.
We can tie him to this through the cell phone.
But the case doesn't end with his conviction.
The detectives completely disregarded the more obvious suspect.
She noticed that he had blood on his t-shirt and that he had a gun.
The detective whispered to me, no hope. The fix was in from the beginning to the end.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
2006 was a dangerous year on the Philadelphia streets. Among more than 400 murders, police were called to the scene of a shooting on the city's north side.
On Friday, February 3rd, 2006, police officers assigned to the 23rd Police District responded to a shooting 1500 Seabird Street. Upon arrival, the officers found the victim, Tyrese Gaiman, 23-year-old black male, suffering from gunshot wounds to the chest. A case of this nature, especially a busy year like '06, the squad is getting murders almost on a daily basis. It's all about the victim. We would make sure that whoever did this crime would get what they deserved.
Detectives questioned eyewitnesses who saw Tyrese Gaiman being chased by a man in a black hooded sweatshirt. The stranger cornered Tyrese and opened fire, hitting him 4 times. Police soon learned that Tyrese wasn't just a random victim.
The murder of Tyrese Gaiman is, officials say, a story of intimidation and vengeance.
It's a total heartbreak on our family.
Tyrese had been scheduled to testify in a murder case when he was gunned down.
Tyrese was a witness in this case and had cooperated in the investigation that ultimately led to the arrest of Kareem Glass, a 25-year-old male who's currently incarcerated and awaiting trial.
If he didn't testify, he wouldn't be dead.
In 2006, Philadelphia had the highest murder rate of America's biggest cities. Witness killings compounded the problem faced by an already overtaxed police department.
Witness intimidation really puts the brakes on trying to solve a murder investigation, because if people are in fear for their lives, as they should be, and it's a legitimate worry, they're not willing to cooperate.
Children are dying out here in these streets. This is serious.
Members of the group Men United for a Better Philadelphia say they're outraged by this T-shirt that says, "Stop snitching." They say it's meant to discourage witnesses of violent crimes from speaking with police and promotes a negative so-called street code of silence.
We did an investigative project on the fact that Philadelphia's criminal justice system seemed to be broken. It had one of the lowest conviction rates in America and one of the highest fugitive rates, and a massive problem with unchecked witness fear. The criminal justice system takes that as an affront, you know, when you gun down a witness.
Police zeroed in on Kareem Glass, a suspected drug dealer awaiting his murder trial in jail. Scrutinizing his visitation logs, investigators came across the name of Dante Thomas. Thomas had a lengthy rap sheet, and after eyewitnesses ID'd him as the shooter, police closed in.
You're coming in heavy because you're serving a warrant looking for a murderer. We already know what they did, so you're not taking any chances. This TV stuff of 2 people in suits and ties knocking on a door doesn't cut it.
It was around 6-something in the morning, and I looked out the window, and it was SWAT people with guns pointing to the windows, you know. So I opened the door, and they was right there in the hallway. And they said, "Where Dante at?" And he said, "I'm right here," because he was laying on the futon in the living room.
I remember my mom came in my sister's room, and she was crying. She was like, "Get up, just get up." There were cops' cars outside. We couldn't move. There were guns everywhere. It was something scary. I won't forget it.
And that was it. Then they left and took him out the house. He been going ever since.
With Dante Thomas in custody, detectives pressed him for information about the murder.
In an interview, he said, well, you're being charged with a murder of a Tyrese Gaiman. I said, I don't know who that is. He said, well, do you know who Kareem Glass is? I'm like, I know exactly who Kareem Glass is. They're like, okay, well, you conspired with him.
Under questioning, Thomas admitted that he smuggled a cell phone to Kareem Glass in a jail visit, just 3 days before Tyrese's murder.
They asked me, did Kareem Glass ever ask me to do anything for him? And I stated, yes, he did. He asked me to give him some marijuana and a cell phone. At the time, I'm like, if I'm innocent, let me give all these people all the facts, anything that I'm involved in where hopefully they sort this out. And I'm like, I don't know anything about no murder. And he definitely didn't ask me to commit no murder for him. I didn't know that they were going to go down a whole nother road that they went down.
Police charged Dante Thomas with the murder of Tyrese Gaiman. On September 10th, 2007, opening statements began in Thomas's trial. His girlfriend, Tamika, had hired well-known defense attorney Nino Tenari to represent him.
Everybody else was talking about $50,000, and I knew our families didn't have $50,000, so Nino said he would charge us $25,000. He made me think that he would do his job. You know, I thought that Dante would definitely be home.
Veteran prosecutor Mike Berry argued the case for the state and painted Thomas as a hitman, taking orders from Kareem Glass.
This is a portion of the statement from Mr. Berry. Tyrese Allen was killed because he was a witness on another homicide. We know that Kareem Glass is the person who had the motive to kill Tyrese. We know that Dante Thomas is a good friend. We know he fits the description of the shooter. I remember him telling us that it wasn't going to be like Law and Order. He said, you watch TV and, all of the evidence lines up very much like a puzzle. And this particular case was not going to be like Law and Order. And I remember that because at the end of the case, it was kind of like Law and Order because they did have a lot of evidence that did kind of line up.
The prosecution called 2 witnesses, cousins of the victim, who had identified Thomas in photo arrays.
The way they described what happened, they were absolutely sure, like, that's the boy who shot at my cousin and chased him into the alley. So for me, it was, pretty compelling.
On September 18th, 2007, the jury deliberated for less than 3 hours before reaching a verdict.
Next thing you know, Nino called and was like, y'all come on back to the courtroom and it don't look good. And it wasn't good. They said he was guilty real fast. That part happened real quick.
Dante Thomas was sentenced to death by lethal injection.
I didn't believe that Nino Tenari put on any defense, so I knew that I was getting convicted, and I watched everything play out. I would have convicted me based off this presentation. My family was there, all the cops was there, and I turned to look back at my family, and the lead detective whispered to me, no hope. I was processing what death would be like, especially for something you didn't do. Actually, it was another death row inmate that said, no, calm down, young man, listen, there's a process here. And that's what put me on my drive to learn everything about that process.
Dante is not a follower, so you can't tell him what to do. Dante does what he wants to do. He started sneaking out the house, and then he started thinking that my rules was too strict. When he was 13 years old, he had taken someone's earrings. We went to court. They sent him away for a while, and he did his time and came home.
Before I started getting in trouble, I started getting in trouble with my mother. I would run away because she wouldn't want me to hang with a certain group of people. I would go run away and hang with the guys on 11th Street. You got prostitutes out there, you got drug dealers out there, and we're kids watching it.
By the time Dante was in his mid-20s, he was a low-level drug dealer. In 2003, life on the streets caught up to him.
The first time I got shot was over a fight. I won the fight, and he came back and shot me.
First time he got shot 5 times. 2 years later, he got shot 15 times throughout his whole body.
His arm was hanging off from his shoulder, and he had staples in his chest and staples in his arm. He had a rod in his hip on the right side from his hip to his knee because his femoral bone in his thigh was shattered. And they had to put that rod in there, which is still there.
It left me disabled completely. I had stents put in my heart and half of my lung removed. It broke my arm completely, and it was devastating.
6 months after Dante was shot, he was arrested for the murder of Tyrese Gaiman. Dante's mother studied nursing and was helping him recover when Tyrese was gunned down.
His hand was constricted, and he's walking with a cane. This is why I was like, I couldn't understand how could they even suggest he did something like that. He couldn't shoot a gun. I used to document things I do in my little calendar books, because this is my child, and I was writing down things that needed to be brought up to give to Nino Teneri, his attorney. But he never brought that to the jury. He never let them know that.
Dante's attorney, Nino Teneri, was a prominent litigator, known for his handling of high-profile cases in Philadelphia. But as the trial date approached, Dante began to feel neglected.
As it was getting closer and closer to trial, Dante was like, Nino need to come talk to me. He still ain't come up here. Then I would ask Nino. He just would say, I'm going up there. Next thing you know, he was saying, I'll talk to him right before trial.
The defendant didn't really put on a strong defense. They were saying like his finger hurt or like his hand hurt and he couldn't have shot the gun. And I thought that wasn't as believable of a defense, which made me question like his truthfulness.
The day of jury selection, I say to Nino, can we talk about this case? He said, no, listen, let's focus on picking the right jury. Then after jury selection, we spun right into trial, like immediately. So I was always behind the 8 ball, and the fact that I was illiterate to everything dealing with the law, I was pretty much in for the ride.
This is a letter from Nino Teneri after Dante was found guilty. Dear Dante, you know that I have the deepest respect for you and your family. As you were disappointed with the results, so was I. Very truly yours, Nino V. Teneri. Nino could have did more, way more.
Now on death row, Dante began searching for a new attorney to handle his appeals.
Guy up here, he was already through the process, and I asked him, I said, if you could do it all over again, what attorney would you use? And he said, well, the only ethical lawyer I ever ran into was Terry Heimbach.
Terry Heimbaugh was an appeals attorney with a reputation for fighting wrongful convictions.
Dear Ms. Heimbaugh, this is Dante Thomas. As of today, I've been on death row for exactly 7 years now for a crime I did not commit. It takes a lot for me to trust a client. I trust but verify. Never forget that my clients often will try and tell me things that they think that I want to hear as opposed to the truth.
As Terry investigated Dante's case, she learned his attorney, Nino Tenari, had never visited him prior to trial.
There's a rule. If you're going to represent a capital defendant, because the stakes are so high, that you must have at least one in-person meeting. An attorney's failure to visit a capital defendant prior to trial is ineffective assistance of counsel, violating the Sixth Amendment of the United States Constitution.
Terry also discovered there were several witnesses who could have given Dante an alibi for the time of the murder. But Nino Tenari never called them to testify. To get answers, Terry turned to private investigator Jeff Stein.
The first person I sat down with and spoke to was Tamika, his girlfriend or fiancée at that time. Tamika gave a very detailed overview of that morning when the murder happened, that she was in bed with Dante. They were in their apartment together. They had a friend of hers at the time who was living with them.
Tasia was a friend of mine. Tasia came to stay with me because she didn't have anywhere to go with her baby.
I didn't recall seeing anything about her in the police reports. That's when a red flag goes up for an investigator. You need to speak to everybody.
Dante's house guest, Tasia, also had critical information, but she was never called to testify.
She shared with me that there was 2 people the morning of the shooting that came to the house. And the first person that came, she opened the door and she noticed that he had blood on his t-shirt and that he had a gun, and he asked for Dante.
A female acquaintance of Tamika's woke me up and said, "You got company at the door." So I go to the door and it's wanted. And he was already talking when I came in there, and it was reckless talk of shootings and stuff like that. I said, "Hope you got roll."
Kwashimi Wagner, also known as Wanted, was a more likely suspect, and notably, several months after this crime took place, he was arrested for shooting 2 individuals.
Dante told Terry that he'd first met Wanted 3 days before the murder.
When I visited Kareem Glass, he happens to be at the jail trying to visit him as well. They asked us, "Do we want to go in together?" I didn't mind. How I'm familiar with Wanted, he was a rapper from the neighborhood. And I have some friends who work in studios, and Glass was introducing us for that purpose solely. After the visit, Wanted drove me home and dropped me off at my house. We talked for a few minutes. I told him I would make some contacts with some people in the studios for him, and he left.
Dante says the next time he saw Wanted was when he showed up at Dante's door with blood on his clothing, moments after Tyrese Gaiman had been killed. Despite witnesses to this visit, the encounter was never brought up at Dante's trial.
There was never, ever any evidence presented that Wanted was an alternative suspect, much less that Wanted showed up the day of the crime 10 minutes after with blood on him. Had counsel done his homework, so to speak, he could have pointed the finger very easily at Wanted. Because counsel didn't speak with Dante a single time substantively about the case, he had no idea the significance that Wanted had, and he never bothered to call Wanted.
Prosecutors believed Wanted may have been involved, but they never had enough evidence to indict him.
The detectives made a determination of who they wanted to be the doer, and then they made sure that the evidence all pointed in that direction. And they completely disregarded the more obvious suspect.
Why did the police set their eyes on Dante? I don't know. I can speculate. It's to close one chapter. He's been involved with other shootings, other drug dealings, and now his name is being brought up.
They couldn't put one on death row. He was a kid. On paper, I was a bad guy.
Among the case files, Terry learned there were other witnesses to the murder, whose descriptions of the shooter pointed towards wanted.
They said that the shooter was a red-boned male, meaning light-skinned African-American. As you can see in these pictures, Wanted is a light-skinned African-American.
There was a person standing in the alley looking at the shooting, and he described the guy as about 6 feet, red bone. That's not my son. He's darker than I am.
While some witnesses had picked Dante out of a photo array, the way Dante's image was used raised questions.
Normally what happens is that there's supposed to be a minimum of 7 pictures, people similar to one another in complexion, in height, in weight, and age. It should be a current picture and just one picture of the particular person.
Photo arrays in a police lineup can be very suggestive. And in this particular case, they had 2 sets of photo arrays, and they had Dante's picture on both of them. He's the only person that was duplicated on these photo arrays.
Someone who was a witness, even if they don't pick that individual from the array, the fact that they've seen that same person show up in the array several times lends them more likely to pick that individual as being the person they saw. Eyewitness testimony is tricky to start with. There is a lot of scientific evidence that there's a tremendous amount of witness misidentification that goes on. In fact, the vast majority of wrongful convictions are caused by misidentification of witnesses.
Prosecutors had argued that Dante committed murder as a hitman, but that theory was about to be tested. On September 18, 2007, the same day Dante was convicted of murder, Kareem Glass was charged with ordering the hit.
The Commonwealth's theory of the case was that Kareem Glass had hired Dante to kill Tyrese in order to prevent him from testifying against Kareem Glass. The irony is that Dante was convicted and Mr. Glass was not.
In 2008, while Dante Thomas was on Pennsylvania's death row, Assistant DA Mike Berry turned his attention to Dante's alleged co-conspirator, Kareem Glass.
Mike Berry had a very good reputation for being a very, very zealous prosecutor. He represented the Commonwealth in the Kareem Glass case as well as Dante's case.
Mike was a very hard-nosed, very dedicated prosecutor. What I would call him is a true believer. And he believed that he was wearing the white hat. He believed that he was doing justice. I think he saw everything black and white and didn't see a lot of gray.
During Dante's trial, Mike Berry had successfully argued that Glass ordered Dante to commit murder. But when Glass's day in court came, his attorney, Jack McMahon, argued otherwise.
Conspiracy is an agreement between 2 people to do a specific act. So they would have to show that Kareem and Dante agreed. They made an agreement, whether it be by a phone, by a message. From what I saw, there was no evidence to suggest that Kareem Glass conspired with Mr. Thomas to do this.
At the center of Mike Berry's argument was the cell phone Dante had smuggled into Glass in jail.
The worst I did was give Kareem Glass some marijuana and a cell phone. That was it. And that's the only real conspiracy piece of evidence that tied me and Glass up.
I think what happened is Dante came in to the police department and told them that he had assisted smuggling in the cell phone. I think that the detectives determined that he's our most likely suspect and that we can then tie him to this through the cell phone.
The prosecution argued that Kareem Glass made 118 calls from the smuggled cell phone, allegedly planning the crime with Dante.
I spent hours calling those 118 phone numbers to determine whether any of them had any relationship to Dante, Dante's family, Dante's friends, Dante's girlfriend, and there was no connection at all between any of these 118 calls and Dante Thomas.
While phone records were brought up in court, the state could never produce the cell phone used by Kareem Glass.
They claimed that this phone was confiscated. However, when we subpoenaed that information from the prison records in Philadelphia, there was no documentation of any cell phone that was found.
Ultimately, Mike Berry decided to drop the conspiracy charges against Glass, raising the question of how Dante was convicted on the same evidence.
I don't think if it hadn't been for the 118 calls, that there would have been as easy for the jury to convict Dante.
What happened was Nino Teneri didn't understand the evidence. Had he asked me anything about the 118 calls, I would have let him know me and Kareem Glass never had any conversation on a cell phone.
The weapon was never found. There's no forensic evidence linking Dante to the crime at all.
Kareem Glass contacted me and said, yo, I read your opinion, man. They use evidence against you that don't exist. I compared the paperwork, and it's like they went to his trial, told a whole nother story. The fix was in from the beginning to the end.
Kareem Glass was convicted of first-degree murder on October 21st, 2008. But prosecutors were never able to tie him to the murder that had landed Dante Thomas on death row. From Glass's trial, Dante learned that he was first implicated in his case by a jailhouse snitch named Eddie Almodovar.
Eddie Almodovar really was the invisible man because he never was a witness. He had a huge impact on this case, and yet he was always behind the scenes. He was never put in front of the jury. They were never asked to make a credibility determination on him. And yet it was because of his testimony that the spotlight was turned on Dante.
Almodovar had told police that Glass had confided in him about the murder.
This is a statement from a homicide unit of Eddie Almodovar. Mr. Glass said, I'm going to tell you something. Don't tell nobody. Don's the one that killed him. He did that favor for me. That's my boy.
He said Kareem Glass had admitted to him that his guy, Dante, had taken care of the witness in his case, and that this was done as a favor to him in order to protect Kareem from the prosecution.
Despite Almodovar's claim, the prosecution never called him to present the supposedly damning information at Dante's trial.
It was key to me to see that that was left out. Oftentimes you can find where the Commonwealth's case has problems by looking at what they don't present.
Prison snitches are rampant around our system, particularly the higher level of the case, the more serious the case, the more the snitches come out of the woodwork. Those types of snitches, to me, almost should be illegal. I mean, there are guys in prison usually trying to just save themselves or try to gain something for themselves. You know, they're just inherently unreliable.
Terry took a close look at Almodovar's prison records, and what she discovered further threw his statement into question.
The day after the murder, Glass got put in the restricted housing unit, where he's single cell status, no contact with any other individuals. Glass and Almodovar would not have even been able to even communicate through the bars to each other. It was not possible. Physically just wasn't possible. When you start looking at all of this, it becomes much more obvious that this was a fabricated case, that this was made up in order to justify who that they've decided was the perpetrator.
This whole thing, this whole city criminal justice system is jacked up. It's been jacked up. It ain't just get like this. It's been this way, and it needs to be fixed.
At the time of Dante's conviction, Philadelphia had the highest incarceration rate of America's largest cities. Officials here had long taken a hardline approach towards justice.
Philadelphia's criminal justice system was probably largely shaped by two people, and that's Frank Rizzo, who was the police commissioner in the 60s and then later became the mayor, and District Attorney Lynn Abraham, who was the top city prosecutor for about 20 years here. And they both prided themselves on being very tough customers. Rizzo was kind of a proto-Trump, conservative, law and order guy to the max. He once boasted that his police department could invade Cuba and win.
You know, we took the Black Panthers on. 3 of my guys shot. Not one Panther shot. And all the opportunity in the world to do it. We don't do things like that. We're professionals. We don't enforce the law and met out punishment. We just apprehend, leave that to the judicial system. But we hope that they would get a little tougher.
Like Rizzo, District Attorney Lynn Abraham set the tone for her prosecutors. During her tenure, 108 people, including Dante Thomas, were sentenced to death row.
Abraham, in her own way, was equally tough and conservative. She was labeled America's deadliest DA, and that reflected the fact that her office sought and obtained so many death sentences.
You don't meet a tougher prosecutor than I am. Don't give me any excuses if you've robbed or killed somebody that your mother didn't love you. I'm really not interested. You're responsible, you have to pay the price.
Her office and the prosecutors that she had there went all out for the death penalty. I guess their job is to get the conviction rates. It was more so of conviction than fairness.
In 2017, Philadelphia's citizens elected civil rights attorney Larry Krasner as DA. Krasner vowed to reform the criminal justice system.
That vision is of a criminal justice system that makes things better, that is just, that is based on preventing crime, and is based on building up society rather than tearing it apart.
Krasner's election gave new hope to Dante and other defendants who believed they were victims of overreaching prosecutors.
Krasner was a prominent defense attorney in town who had handled many cases representing victims of police abuse. And he sort of came out of nowhere to win the office. He's pledged to try to reverse unfair verdicts and take an objective look at controversial murder cases.
In my opinion, the criminal element in the city is very happy with what's going on in the DA's office. Defense attorneys, they're salivating. They can't wait to get into a courtroom because they know they're going to walk in one door and the defendant's going to walk out another.
I want what you want. I want justice. And no, I will never seek the death penalty.
Philadelphia's new DA, Larry Krasner, took office on January 2nd, 2018. 3 days later, he sprang into action.
It was an extraordinary sight this afternoon. Over 24 prosecutors from the Philadelphia's DA's office were axed, and their departures were played out in public for all to see.
The purge was on full display as the file boxes kept rolling out of the DA's office. 31 staffers, including a number of murder squad prosecutors, high-ranking deputies, and division chiefs, were among those terminated.
One of the first things that Larry Krasner did when he took office was to clean house. And he cleaned house of individuals who didn't have the same vision that he had. And that included Michael Berry, the prosecutor in Dante's case.
He let a lot of the staff go, particularly in the homicide unit. He thought that the homicide unit was overly zealous, too bent on winning as opposed to delivering justice.
With the new progressive DA in charge, Terry hoped that Dante's conviction would be thrown out.
We're hoping to have a post-conviction appellate hearing where we anticipate we have multiple claims of ineffective assistance of counsel and prosecutorial misconduct. Dante's not interested in just serving life in prison. He wants to get back to his family.
I hope that the evidence is presented and interpreted for what it is. I'm the innocent man put on death row, and I should be back home with my family. That's what I hope.
But in early 2019, Krasner's office unexpectedly filed a motion to dismiss Dante's appeal. It will now be up to the Pennsylvania Court of Common Pleas whether to re-examine Dante's case.
Well, I gave it to God, and I'm thinking positive. And the way that his case is going so far, I trust and believe that he should be exonerated.
Now I speak to Dante every day. Several times a day we talk. I know he got a good chance of coming home. I don't want to think that he's not coming home. I don't ever have that thought in my head that he's not coming home.
I haven't touched my dad since I was 5 years old. I haven't physically hugged him. I feel like Joe, like, it took my dad from me. And I didn't have, like, the male figure I needed. And, I needed him most. Like, I'm grown now, so it's like, it's not really much you can teach me that my mom didn't.
While Dante's family suffers from his absence, they haven't lost sight of the victim's family.
I'm sad and so sorry that they were served this fake justice. The young man deserved better than that. Their family deserved better than that.
I think it was bad and tough for both families. I know it was for this family. And if they love this loved one like we love Dante, yes, then I'm sure that it was rough for them. And being a mother or a grandmother, whoever, I mean, if you got love in your heart, it's going to be tough on you. Yeah, it's going to be rough.
Terry has been working on Dante's appeals for over a decade.
While his case is pending appeal, his execution is stayed. I go to bed each night knowing that if I don't do my job to the very best of my efforts, that someone could die on my watch. And that's something I think about all the time.
I maintain hope by learning everything there is to know about the law, by educating myself every day and studying and reading and practicing, because you need all the information you can get to fight for your life back.
On this episode of Death Row Stories, in rural Ohio, a shocking double murder.
It was just unbelievable that in this quiet little neighborhood, something would happen.
An elderly couple murdered at their kitchen table.
There was no sign of a struggle.
There were no signs of forced entry.
As if they knew their attacker.
The case goes cold.
You don't want to have unsolved murder cases.
Until the DA hunts down 4 likely suspects.
These were lost boys.
23 years later, is an innocent man on death row?
He said, "I'm begging you to spare my life." Maybe someday the truth will come out.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
Saturday, April 7th, 1990. It is approximately 8:33 p.m.
On a Saturday afternoon, my dispatch called me and advised me that there had been a crime committed, a murder.
In the remote Ohio town of Atwater, 81-year-old Cora and Bernhard Hardig were discovered shot to death at their kitchen table.
A neighbor was surprised that the Hardigs' garage door was open and there was a tractor outside. And then he called the sheriff's office because Mr. Hardig apparently cleaned everything and put everything away every night.
Watch your language, you got tape running here.
Police entered a crime scene that was absolutely grisly. The Hardigs were found in the kitchen. Cora was shot 5 times. Bernhard 3 times. They were terribly discolored, bloated. They were unrecognizable.
Bernhard Hardig had worked at the deli counter of a supermarket before retiring. Cora was a homemaker.
Cora and Bernhard were known to be fastidious folks. Bernhard kept his lawn pristine. Everything was in its place. I remember seeing a photo of them. She's leaning into him, and he looks proud as a high school senior with his prom date.
They kept to themselves. They were good neighbors from what we were told. It was just unbelievable that in this quiet little neighborhood, something would happen to them of, this degree.
We believe, money was the motive. That's our speculation at this point.
Despite the grisly scene, the killer left no fingerprints or footprints. All police found were a cigarette butt in the driveway and some shell casings. The shell casings would lead police to their prime suspects. In the days leading up to the murders, 4 young men had been on a crime spree in Alliance, Ohio, 10 miles away. 14-year-old Butch Walcott, 18-year-old Joey D'Alessandro, 21-year-old Gary Sinclair, and their leader, 18-year-old Tyrone Noling.
They started with just car larceny type things. They would take change out of ashtrays and CB radios. They were known to cause problems, just little troublemakers.
2 days before the Hardigs were killed, Tyrone persuaded Gary St. Clair to join him in burglarizing neighborhood homes.
They had this ruse. They went in, asked the people if they could use their phone, and then they took stuff from them, rings and jewelry and all kinds of stuff.
They took everything that wasn't nailed down. At the first house, Tyrone found a .25 caliber weapon and uses it the next day, April 5th, in the second robbery.
Detectives were initially interested in them as suspects in the Hardig murder because a .25 caliber pistol was used to kill the Hardigs that same day.
They were trying to get money to buy cigarettes, video games, and snacks, and get high.
Butch and Gary had met at a homeless shelter. Joey and Tyrone were friends from childhood. All 4 boys had been crashing at a friend's house, unsupervised, broke, and bored.
Tyrone and the others were lost boys. They were drifters in their own lives, and they drifted together. They were living kind of a Lord of the Flies life in this empty home where there were no parents and no rules, no plans, and no life.
Police arrested all 4 boys for the robberies 4 days after the Hardigs were murdered. Tyrone and Gary immediately confessed. Butch and Joey, who didn't participate in the burglaries, were released.
Both Tyrone and Gary were in jail on the Alliance robberies. Detectives went down, interviewed both of them about the Hardig murder. Both of them were denied involvement.
Police also ran a ballistics test on the gun they took from Tyrone.
Bureau of Criminal Investigation excluded it as the murder weapon, 100%. That gun was not the gun that was used to kill the Hardigs.
Taken from the driveway of the Hardig home was a cigarette butt. And this got great attention because the Hardigs didn't smoke.
I tested the saliva present on the cigarette butt and determined a blood type. It indicated that all 4 suspects could not be the source of the saliva.
After that, they had to be ruled out as suspects. Tyrone Knowling went on to serve his time for the robberies he'd admitted to. Gary did the same, 5 to 25 years.
I do not think that these boys were capable of that. These boys had just done mischievous crimes, so to speak. I never thought it was them.
With no leads or eyewitnesses, the Hardigs' murder went cold.
I try to disconnect myself from the outside world because it's the only way I can deal with it in me. It's the only way I can cope with it.
In 1992, 2 years into his burglary sentence, Tyrone was visited in prison by investigators in the Hardig case. They delivered shocking news.
Detective says I'm being charged with 2 first-degree murders.
What was your reaction?
What would your reaction be? It was like, you gotta be kidding me. These people are crazy.
Hi, is this David Norris?
Yes, it is.
Hi, sir. This is Andrea Samakis calling from the Plain Dealer.
Right.
Journalist Andrea Samakis interviewed Portage County prosecuting attorney David Norris about the Hardig case.
You don't want to have unsolved murder cases.
Right.
When you only got 3 or 4 a year, you want to do everything possible to solve it.
To reinvestigate the case, Norris assigned Ron Craig, a former police detective who had helped win several convictions.
Investigator Ron Craig has a reputation, one that is aggressive.
He would get a hold of a case and he wouldn't let go of it, and that's what happened here.
I just told Ron, take the file, look at it, snoop around, do whatever you got to do, because I want to make sure that we've done everything we can do on this.
Ron Craig and I went to school together, played football together. He's been called a bully. He tried to bully me, okay? Even when I was sheriff.
Once Ron Craig was brought onto the case, things started moving very quickly.
Within several weeks, they focused exclusively on Tyrone Knowling, Butch Wolcott, Gary St. Clair, Joey D'Alessandro.
Tyrone and Gary were serving out their sentences for robbery. Joey D'Alessandro was in jail on a drug charge, while Butch Wolcott was back at home. Ron Craig started by going after 16-year-old Butch.
They said, we're pretty certain that you gentlemen were involved with a murder.
Ron Craig told Butch his DNA was found at the crime scene, told him a man on a utility pole had seen him committing the crime. On the one hand, he was facing life in jail. On the other hand, the state was offering complete immunity.
I was advised by everybody in my family to cooperate at all costs. Yeah, I cooperated.
Butch agreed to testify that his 3 friends had committed the Hardig murders.
After Ron Craig gets Butch to agree, Ron Craig also gets Gary St. Clair and Joey D'Alessandro to agree to confess to the crimes and finger Tyrone Knowling as the trigger man. Ron Craig, basically convinced them to testify against Tyrone Knowling to save themselves.
By August of 1995, Craig had arranged plea deals with Gary and Joey. Tyrone Knowling was indicted for the aggravated murder of the Hardigs, a charge that carried the death penalty.
The person who hired me was Tyrone Knowling's defense attorney. I never have done a death penalty case before this case. This was the first time.
As Tyrone's defense prepared for trial, they brought on investigator Vicki Buckwalter.
Vicki Buckwalter, I believe, cracked the Tyrone Knowling case wide open.
I got a pile of statements from the co-defendants of Tyrone Knowling. And it seemed that the more evidence that came to light in this case, their statements would suddenly change to kind of match the evidence.
Vicki concentrated on Gary St. Clair, who had agreed to plead guilty to his involvement in the murders in exchange for a 23-to-life sentence.
He's their star witness because he supposedly is in the house with Tyrone. He's the eyewitness, the only eyewitness to this murder. We went up there and talked to him, and we couldn't turn the tape recorder on fast enough. I mean, he just told a story, and we just listened to it.
Vicki Buckwalter and her partner, they talked to me, about the murder case, and they pretty much wanted me to go in the courtroom and lie.
He said, I don't know what to do. And I said, Gary, I'm not your attorney, and I cannot tell you what to do, but the truth is always the best thing.
Vicki Buckwalter's a hard-working lady. I trust her. She talked me into it. They told the truth at Tyrone Knowling's trial.
He said, I'm going to tell the truth.
As Tyrone Knowling's trial loomed, his defense team uncovered several facts that seemed to challenge the prosecution's case.
When you compare the crimes of the Hardig murders to the crimes of the robberies and Alliance, you see a world of difference.
The evidence at the crime scene suggests both Bernard and Cora were shot while sitting around the kitchen table. There were no signs of forced entry.
There was no sign of a struggle. It appeared as if they knew their attacker.
In the Alliance robberies, they were after jewelry, cash, electronics. Those things were left in plain sight in the Hardig murder. All of the Alliance robberies were within walking distance of the house that they were staying at. They would run through the backyard, commit a robbery, and then run back to this house. The Hardigs lived miles away, the next county over, about a 20 or 30-minute drive, completely out in the middle of nowhere.
Police also didn't find fingerprints, any trace evidence, not blood, not hair.
When the boys did the two robberies, they went in with no masks, easily recognizable, left their fingerprints all over the place. All these things that you would expect from kids who had no idea what they were doing.
On January 8th, 1996, Tyrone's death penalty trial began.
There is no physical evidence linking him to the crime. The evidence against him is largely resting on the testimony of his three alleged accomplices, Butch Walcott, Joey D'Alessandro, and Gary St. Clair.
The prosecution called Butch Walcott to the stand. Now 20 years old, Butch testified that Joey drove them to the town of Atwater, where Tyrone chose the Hardig's house to rob. Joey D'Alessandro confirmed Butch's testimony, saying they waited in his car while Tyrone and Gary committed the murders.
Joey testifies about seeing Tyrone run from the Hardig ranch with a smoking gun in his hand. I mean, this was dramatic testimony.
Next, it was Gary St. Clair's turn to testify, but on the stand, he stunned the courtroom.
I told the jury and the judge that Mr. Knowling didn't have anything to do with the murder case, didn't kill nobody. And the prosecutor jumped out of his chair. The prosecutor had no idea that I was going to say that we're innocent of his murder case. He had no idea.
This was the guy who was supposedly in the house with Tyrone. Joey and Butch were supposedly waiting in the car as the story went. He's not going to testify against Tyrone. Imagine the drama of this.
The judge called a break or something. We ended up going to a small room, and I told the prosecutor. He came and asked me why I did that. I said, well, I'm telling the truth. And I said, Ron Craig wanted me to lie for his benefit and the prosecutor's benefit to get the case over with.
The prosecutor responded by telling Gary his goose was cooked. He was done.
After this happened, we go back in the courtroom. The prosecutor started to talk to me, as a hostile witness.
The prosecution read to the jury a sworn statement Gary had made, describing in detail how Tyrone committed the murders. At trial, Gary said he only agreed to cooperate after being threatened with the death penalty.
I'm gonna make sure I max him out on everything if I don't testify against him. There had been a maximum sentence on every charge.
And even with that risk, you decided to tell the truth.
Yeah, even with the risk, I told the truth for this murder case.
And why did you do that?
Well, I told the truth. If the day would come where Tyrone Nolan would get, put to death, it won't be my conscience. I care the rest of my life if he got put to death. I don't want to have that. I want to, just tell the truth.
After Gary's testimony, he returned to prison to serve out his sentence for the Hardig murders. Joey D'Alessandro pled guilty to a lesser charge and got 5 to 15 years. On January 23, 1996, the jury returned its verdict for Tyrone Nolan.
I was so confident that this guy, he's innocent, he's never going to get convicted. I think I was naive in a lot of ways.
The trial ended with Tyrone Nolan being found guilty of the murders of Cora and Bernhard Hardig. Tyrone Nolan was sentenced to death. The judge asked the condemned man if he had anything to say. Tyrone Nolan said, "The crime he was convicted of was sick, hideous. I couldn't do that. I couldn't do it, and I'm begging you to spare my life. Someday," he said, before his knees gave way and he had to sit down, "maybe someday the truth will come out."
With Tyrone Nolan sentenced to death, defense investigator Vicky Buckwalter tracked down his remaining accusers. For his cooperation, Joey D'Alessandro had received a reduced sentence of 5 to 15 years. Butch Walcott received immunity and went free.
I started out with Butch first. I knocked on his door, and I told him that I thought he had things confused, that he didn't actually do these murders. He looked at me like the weight of the world was just had been lifted off of his shoulders.
I always wanted to tell the truth, just didn't realize that I could.
And what made you realize you could?
Vicky Buckwalter. That's my angel. And maybe she's Tyrone's angel. She might be all of our angels.
He said, I wasn't there at the murders. I knew what was going on, and I know that none of us were there.
Butch, just 16 years old at the time, described how he was pressured into lying in court by the prosecution's investigator, Ron Craig.
I was interrogated for 90 hours. He wouldn't let my dad in.
None of the things that Ron Craig told Butch Walcott that he had on him were true, but cops are allowed to lie to folks they have in the interrogation room, and he did.
They said they found my DNA in a cigarette butt. It was all lies. I feel like such a fool. You have no idea how much of a fool I feel.
Ron Craig knew very well that Butch would be the easiest link to flip on his murder case. He's young, about 14 years old. Younger you are, I guess the easier to scare.
One time, he took me to the bathroom. He opened the door. He said, "Step in." He closed the door. standing here in the middle of the dark. A few seconds went by. He opens the door and he flips the switch. And he said, see how everything is here now? That's the difference between you telling that little white lie and not. Flip that switch off, there's nothing there. When they have the power of life and death in their hands, trust me, that's really scary.
He was coached. He learned things about the crime scene through being left in a room with evidence files.
Photographs started getting shown. Slid them right over to me. Do you recognize this? Nope. But they did this 7, 8, 10 times.
At one point, Butch was taken back to the crime scene. Ron Craig felt that it would jog his memory. And of course, once they take him to the crime scene, he can now describe the house.
As we're driving, we start slowing down. He's up in his rearview mirror. He's looking up at the house, looks back down at me. Do you recognize this? And even as a youngster, I could pay attention to cues. It's that house. That's it. I know how Craig is at this point. He expects results.
With Butch now cooperating, Ron Craig next turned to Joey D'Alessandro.
Joey said, my mom told me that if I didn't plead, she would never come to visit me in prison. His dad wanted him to plead. They felt like if they pled, at least they could try to get out on appeals.
Joey, he lied too. He got scared by Ron Craig. Because I remember reading transcripts saying he was scared. They threw him to the death penalty.
Gary was the last domino to fall. Prosecutor's office took the road of the least resistance, and that's why they went after these boys.
Having obtained sworn recantations from all three of Tyrone's accomplices, in 1997, Tyrone's defense appealed his conviction.
Recantations are looked at with suspicion. The idea is, well, wait a minute. We've got guys who have admitted to us that they've lied. How can we take anything they say seriously? The problem with that logic, as far as I'm concerned, is when they give you good reason for the lie.
And the way to figure out which of those things is true is to look at which one of those stories better matches the facts, which one was made under duress. And in this case, I think all three recantations are more credible than the original inculpatory statements that Joey, Butch, and Gary offered to the prosecution.
Despite these arguments, the court denied Tyrone's appeal. Disappointed but undeterred, Tyrone's defense now turned to other evidence that could compel a rehearing of his case.
When I started looking into the case, I uncovered in my reporting, there was another suspect very early on that actually made more sense than Tyrone Knowling or any of his associates.
Mr. Hardig had a reputation as being generous in loaning money to friends and acquaintances.
Before the murder, Mr. Hardig had been having a money dispute with an insurance salesman, a man named Louis Lehman. They had loaned Lehman $10,000. The loan had come due. Mr. Hardig was mistrustful of banks, and he had kept sort of a large amount of cash on him that he would loan out to friends.
During their investigation, police were approached by the Hardig's doctor, who said that just before Bernhardt was murdered, he'd complained about his loan to Louis Lehman.
Dr. Cron said, Mr. Hardig was extremely upset and said, as soon as I get off the phone with you, I'm going to call him and set this straight. That's the last anyone ever heard from the Hardigs.
In the living room, papers on the floor in disarray.
There were papers strewn around the house, open drawers. Certain parts of the house had been ransacked, but there were also valuables in plain sight that weren't taken.
We always contended somebody came in there who knew the Hardigs. They shot the Hardigs, and then they did a concentrated search for something. Perhaps paperwork that showed that there was indeed a loan.
Detectives brought Louis Lehman in for questioning. Mr. Lehman owned a .25 caliber pistol that could have been used to kill the Hardigs. And when they asked him what happened to that weapon, he said he didn't remember. They asked him to take a polygraph examination, and he refused.
That was pretty much the end of the interview, and he just kind of disappeared off of the radar with them.
Once the prosecutor's office took over the investigation, there's no other mention of Lehman in any of the records that have been uncovered so far.
Lehman died in 1994, and Tyrone's team was never able to question him. But the defense would soon learn about another suspect, a suspect who actually admitted to killing the Hardigs.
Wilson was a young man who actually lived in a foster home very close to the Hardig home.
Nathan Chesley lived with Dan Wilson for 2 years.
I was 16 years old when I moved into that foster home and met Dan Wilson. Dan was like an older brother, I think would be the best way to define our relationship, but one that didn't have much fun involved. He would teach me things like working on cars. It was either work or he would be drunk and he would make me do work. He was a bully.
Wilson had a juvenile record like Tyrone Knowling, but his was deadly.
When Wilson was 14 years old, he beat an 81-year-old man to death and served time in juvenile detention for the murder.
He was already killing people. This is just what he did. One Sunday night, Dan came home about 1 a.m. and he was drunk, and then wake me up out of bed, and he had me go in the garage with him. When Dan was drunk, he had like a split personality, and his voice would change. He would be a totally different person. When he had me out in the garage, he was explaining that he killed the Hardigs and that he had shot them. Dan didn't give me any reason why he did it because he's talking in the third person. So he's like excited, like he's like, do you see what Dan did? Definitely boasting. He actually used his hand like he was pulling a trigger. And it scared the shit out of me. I'm just telling you the truth. He just eventually fell asleep, and that's how I was able to get out of there. The next morning, I started asking him questions. Why would you kill the Hardigs? What was the deal? And his face turned white as a ghost, and he starts choking me on the wall. And he's like, how do I know this? Have I been following him? Was I there? How do I know all this stuff? I couldn't breathe. He's trying to kill me.
The woman who ran the foster home pulled Dan off Nathan, and he managed to escape.
I went to school, and I explained to the principal that I knew who killed the Hardigs. I was very emotional. We sat down, and he said that he was going to be contacting the police. I told him, you can do whatever you want to do. I'm not going to be here anyway. Dan was going to kill me, whether I told on him or not.
Nathan hit the road, eventually becoming a long-haul truck driver. He never spoke to Dan Wilson again.
The police have never tried to contact me about this case. No investigator, no detective, nobody.
The police end up not following up on that thread or connecting it until Dan Wilson is ultimately arrested for this murder several counties over.
In 1991, Daniel Wilson was implicated in the murder of a young woman.
Carolyn Lutz. He met her in a bar, and he took her in her car and threw her in the trunk of the car and lit it, and she burned alive. That's the kind of man Dan Wilson is.
Carol Lutz was murdered 13 months after the Hardigs. Dan Wilson was convicted of her murder in 1992. He was executed by lethal injection in June 2009.
When I found out that he got executed, I just assumed it was the Hardigs. But then I found out that it wasn't for the Hardigs. And that like blew my mind, but I didn't know what to do, because he's already dead. What do you? And then I didn't piece it in my mind together that there was somebody else who's actually on death row for what he did.
The government has an obligation to turn over evidence of innocence in order for defendants to receive a fair trial. Police knew Dan Wilson's blood type was consistent with the blood type on the cigarette butt prior to Tyrone Knowling's trial. There's plenty of evidence that Tyrone Knowling is innocent, and the jury just never heard any of it.
In 2010, Tyrone's defense began filing appeals, arguing that the jury never heard about the alternate suspects. Additionally, recent advances in DNA technology could help prove Tyrone's innocence.
There's other evidence that we know was touched by the perpetrator and that we know has never been DNA tested.
There were shell casings found at the scene. They also found ring boxes that had been pawed through.
In 1993, the technology was not sensitive enough to pick up DNA left by someone touching an object. Over the last 25 years, the technology has improved exponentially. It's now routine for state laboratories to get full DNA profiles off of something that someone has just touched for a few seconds. DNA testing on those ring boxes and the shell casings could be actually compared to these alternate suspects, Louis Lehman or Dan Wilson.
All right. We will now proceed with case number 11-0778, State versus Noling.
In 2013, Tyrone's defense attorneys, Brian Howe and Kerry Wood, began arguing their case in front of the Ohio Supreme Court, requesting that additional DNA testing be conducted.
Of the now well over 300 DNA exonerations, 10 are capital defendants. And so a denial of DNA testing would at least result in some arbitrariness in the imposition of the death penalty.
In a series of hearings over a period of years, State Prosecutor Victor Viglucci argued against any additional DNA testing or the possibility of a new trial.
We're here because DNA testing is going to cause another year or two delay in executing Mr. Noling.
The defense also requested that Nathan Chesley's story finally be reviewed by the court.
I was supposed to go in front of a judge and show the signed affidavit just to be heard. Prosecutor got that blocked.
I really object to the appellant here claiming that this alternative suspect has confessed by some way. He was somebody that police ruled out very early. And then some 20 years later, they produced this affidavit from a foster child who happened to live in the same foster home. And it would be inadmissible hearsay of this Nathan Chesley anyway. Right. I mean, in no way that's coming in at trial.
They're not interested in finding out who did it. Once they have somebody, that's it. They weren't interested.
Mr. Chesley has never testified. It's not true that the Court of Common Pleas has rejected his testimony as incredible or inadmissible. It's never been heard.
At the end, testing was denied on both the ring boxes and the shell casings.
This baffles me, and it baffles me why a prosecutor like Vic Vellucci wouldn't say, okay, let's hear it. We are so convinced we have the right man, we are not afraid to put this case under a microscope and really look at it.
The more that I learned about the facts of the case, the more shocked I was that he had been convicted, that he was still on death row, that he was still in prison even at all. It seemed clear based on the totality of the record that he was 100% innocent of this crime. With a man's life at stake, why would you not want to know every fact? Why would you put your head in the sand about evidence that could potentially resolve what happened here?
Tyrone Noling has been on death row for more than 23 years. 18 when arrested, he is now nearing 50 years old. Gary St. Clair has served 26 years for the Hardig murder. He will be eligible for parole in 2022. Joey D'Alessandro was released after 12 years and is now a free man.
Are you going on the assumption it was some kind of intruder?
That's what we believe.
Ever since Sheriff Howe dismissed them as suspects in 1990, the case against Noling has been driven by the county prosecutor's lead investigator, Ron Craig.
I very much wanted to interview Ron Craig about this, particularly because all three point the finger at Ron Craig as being the person who orchestrated the entire case against Tyrone Noling. That's a really serious accusation to make. I mean, it's malpractice.
in this case?
Sometimes these questionings get aggressive. It's the nature of the beast. Okay. You're not sitting down here with school children. You're sitting down here with murderers. They have obvious reasons to lie and to protect themselves. So sometimes the questioning gets aggressive. It's not unusual and it's not illegal. I mean, neither is it illegal to use ruses or falsehoods in the course of the questioning. I mean, it's an acceptable tactic.
Wouldn't you let me talk to Ron Craig?
No.
Why?
Part of their job is being able to do it without fear of having to be interrogated or questioned by the press later.
All of the charges that have been made against Ron Craig by these young men about him threatening them, terrifying them, leaving them with evidence so they could get more details. If I were a cop, I would absolutely want to defend myself against such allegations. According to what he told me, Prosecutor Vellucci loses no sleep over the allegation that his investigators' tactics put an innocent man on death row.
You do your job. I'm lost to understand why you're wasting your time with this, but that's your time and whatever you want to do.
Vicki Buckwalter has found other cases of questionable convictions connected to Victor Viglucci and Ron Craig.
This guy came into my office and he said that his brother had been wrongfully convicted. Lo and behold, when we started looking into the case, it was the same exact prosecutor and the same exact investigator, Ron Craig. It was like deja vu. We were hearing all of these same things over and over, how they were trying to get people to change testimony and how they were coercing. For this to happen twice, same investigators, same tactics. This is how these guys are getting these convictions, and I can only imagine how many other cases are won this way.
Prosecutor Victor Viglucci and investigator Ron Craig did not respond to numerous requests for comment.
Still have never talked to Tyrone Nolik. I want to contact him and let him know that I know he's innocent, but I don't want it to look like I know the guy or I have any skin in the game, because I don't. If they execute Tyrone Nolik, I don't know mentally how I'll be able to handle that, being that I know I could have stopped that years ago. That'll be real difficult, because I should have stuck around.
Hopefully, Tyrone Nolik will get exonerated. It'll fall towards me. I'll be processed out of the prison, too. And obviously, now get out of there, I'm going to try and find my son. He's, I think, 31 now. He's born in 87. He's 31. He's out there somewhere. I'm going to go look for him, too. Yep.
I have a conscience about what I did. This is a guy that I did the most ultimate wrong to. And even at that age, you can understand that you're damning somebody to death. Every moment, I know where he's at. And I know in my heart that I put him there.
On this episode of Death Row Stories, a liquor store clerk is robbed and gunned down.
I got a phone call in the middle of the night. Your father's been shot.
A teenager confesses on video.
I pulled the trigger.
When I heard he made a confession, my jaw dropped. You have a confession, you have a conviction.
And a judge sentences him to death.
How did he get all of those details exactly right if he wasn't the murderer himself?
But the credibility of the confession comes under fire.
You cannot believe anything in that tape. That man's clearly impaired.
Jermaine Wright understood what he was saying.
How do you make it up to a dead man? Somebody's got to give up their life.
I was innocent, but there I was, on a video.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
On January 14th, 1991, police dispatch took a frantic call from a liquor store just off the highway in Wilmington, Delaware.
I was a homicide detective with the Delaware State Police. As I arrived to Governor Prince Boulevard, I could see the sign that said Highway Inn. It's the liquor store, and I could see there was a number of police cars there. There were people crying, and there were people distraught. I went in, and as I walked into the crime scene, I did see Mr. Seifert.
Behind the counter, 65-year-old store clerk Philip Seifert was lying in a pool of blood. His dentures and eyeglasses lay strewn on the floor. Despite suffering 3 gunshots to the head, Seifert was clinging to life.
You start trying to think who could actually commit the crime, get away, and who might actually have noticed. You try and get any type of witnesses you can.
Inside, police found the cash register broken into, with $30 missing, but no shell casings or fingerprints were left behind. A passerby did see 2 young black men fleeing, but he couldn't provide a detailed description.
I got a phone call in the middle of the night. It was my uncle, and he said, "Your father's been shot, and they're flying him to the hospital."
Two hours later, Philip Seifert, a father of 2 and grandfather of 4, succumbed to his wounds.
An event like this has an impact that is wide-ranging and long-lasting. It's like a piece of you is just gone.
The first 24 hours are the most critical point during the homicide investigation. We put a dot, let's call this dot the Highway Inn, and then you start doing with a radius. So the first radius might be 100 yards wide, and then you go 200 yards wide, then 300 yards, a mile.
Detective Mayfield eventually homed in on a high crime area less than a mile from the crime scene, the Riverside housing projects.
Riverside was a community, it was very open. Most people knew each other, and they knew people's businesses. I went during the night usually, because nighttime, the community was vibrant, and I asked anybody that could talk to me to please talk to me. People started coming in and start giving more information.
But after weeks of dead-end leads, police finally got a break when someone left a tip at the Highway Inn.
There was a handwritten note, and it talked about that the person is Marlo and the address that he lived. Initially, we heard that they were drug dealers, but nobody knew their full names. So we had to go into police officers to do some more investigation to find out. One was Jermaine Marlo Wright.
Police connected 18-year-old Jermaine Wright, who went by the name of Marlo, to 2 previous shootings. On January 30th, 1991, police raided Marlo's home with a SWAT team and brought him in for questioning.
As a homicide investigator, you're taught to listen. If they're telling a lie, you listen to the lie. If they're telling the truth, you listen to the truth. And then you try and sort out the facts. We judged Jermaine Marlo Wright to be truthful. He wasn't a hostile person. He was actually having a conversation like you and I would have.
After 6 hours of interrogation, Marlo agreed to make a videotaped statement. As the camera rolled, he recounted the night of the shooting and named an accomplice, 24-year-old Lorenzo Dixon.
This is Detective Mayfield of the Delaware State Police. Just start from the beginning, Jermaine.
Lorenzo Dixon came and got me about 11 o'clock. He said, "I know it's somebody at by themselves. Let's go down there." So we went down there.
Inside the Highway Inn, what was Lorenzo saying to the old man?
Take all the money out the cash register. Lorenzo seen the man didn't want to cooperate, so he started yelling at me. He told me if I don't do it, he's going to kill me.
Okay. What happens then?
The old man turned his back and started reaching for something. I thought he was reaching for a gun.
And at that point, what did you do?
I pulled the trigger.
After Marlo's confession, police picked up Dixon, who initially denied involvement. Later, however, he accepted a plea of 10 years in exchange for implicating Marlo as the killer. Marlo would face the death penalty. Jermaine Marlo Wright's trial began on August 11, 1992. With no physical evidence or eyewitness accounts, prosecutors rested their case on Marlo's taped confession. Attorney Jack Willard headed up his defense.
Marlo totally denied the crime. He was very, very emphatic that he absolutely didn't do this, that he had an alibi, but he told me that he had made a confession. My jaw dropped.
Willard called 4 of Marlo's friends, who testified they were with him at the time of the murder, playing pool at a local hangout.
I put on what I thought was a great defense. So I thought a reasonable jury could find that that was legitimate. I had in my deepest heart the hope that that would happen.
But Marlo's defense couldn't overcome the strength of his taped confession. After less than 3 hours of deliberation, the jury found him guilty. He was sentenced to death by lethal injection.
I hold my decision as to whether someone is guilty or innocent once I see evidence. I can tell you that when I saw that videotape, that removed any shadow of a doubt in my mind.
Marlo's sentence broke my heart. I was convinced he was not guilty. I've prayed for Marlo from the day he got convicted.
What did you do?
I had pulled the trigger.
Do you remember how many times you pulled the trigger?
Once.
I always told everybody that I didn't do it, I'm gonna get out. I knew that I didn't commit the crime. And there I was, on a video.
Jermaine Marlo Wright grew up in the notorious Riverside housing projects on the outskirts of Wilmington, Delaware.
My mother was a single mother. My father, he was incarcerated, he wasn't around. In the streets of Riverside, you had the drugs, you had the prostitution, you had the fighting, you had the crime. All this negative aspect of low-income living in my neighborhood. I watched people overdose. I saw people get shot. Even though I saw these things, it still didn't stop me from getting high myself, from getting caught up in my environment, the glitz and glam of the drugs, what you could obtain from the drugs. And selling drugs was common in the neighborhood. Getting high was common in the neighborhood. Some guys got high off the drugs they sold. I was one of those guys.
By age 18, Marlo had a $400 a day heroin habit that he bankrolled by selling drugs. This history played a pivotal role during his trial for Philip Seifert's murder.
Marlo told me, "Mr. Willard, I'm a drug dealer, but I'm no killer." He said, "I always had plenty of money. Why in the name of God would I rob a liquor store for $30? I can go out on the street in 5 minutes, make that much money." Just, it didn't make sense for him to commit that.
Willard argued that Marlo was such a successful drug dealer, he had no need to rob a store for pocket change. That strategy backfired.
You cannot go into a courtroom and tell jurors that this guy was a drug dealer, but he's innocent. 12 people who may or may not have a family member who overdosed of drugs. They look at me different because I'm selling drugs. they would never believe that I didn't commit the crime.
We took a huge risk by admitting that this guy's a drug dealer. We talked about that, and we knew that they weren't going to like him for that. I think that ultimately that hurt him. If you deal drugs, you're a criminal in the jury's mind. So you'll commit a murder.
I had no education. I lacked the understanding of the justice system. My trust was in a lawyer who went to school, who went to the education, who knows the law.
In 1992, 20-year-old Marlo Wright left behind his 2 young sons and became the youngest inmate on Delaware's death row. His execution was set for the following year.
The gravity of my situation took a long time to sink in. I was in denial. Once they locked me down, that was it. You're locked in your cell 23 hours and 15 minutes a day. And you're behind that door. You got to look in that mirror. Writing was my release. Everything I felt went on paper. I couldn't talk to you about it, but I could write it down. I can express myself on paper. I always thought that my case was going to be overturned. 94 came, denial. 95, denial, and so on and so on. I maintained a spirit. I still believe that I would get out. Hope is everything.
Marlo's appeals failed for 15 years. But his luck would finally change in 2007 when Jim Moreno of the Capitol Habeas Unit took over his defense.
When we first got Marlo's case, our assessment was that it was in pretty bad shape. We were quite concerned when we first got the case as to whether or not we'd really be able to do anything to help him. I recall thinking, if we saved his life, now it'd be pretty cool.
They knew the law. They know how to fight. They believed in justice. And they believed in my case.
The case against Marlo Wright for the murder of Philip Seifert hinged on Marlo's taped confession. Even for his new defense team, the evidence against Marlo seemed overwhelming.
Well, I'll tell you, when I first watched it, my reaction was like, well, damn. You know, because it's never good having your client on tape admitting to a crime. Everyone thinks, who the hell confesses to murder? We really had to re-examine the circumstances of how this confession was taken from him. After they arrested him, they brought him to an interrogation room, a 7x10 room, windowless. Now, he was handcuffed to a table. Before they turned on the video camera, Marlo had been up for hours. And then we found an important piece of information about his physical state at the time that he was being interrogated by the police.
When I was arrested, I had heroin in my possession, which they didn't find. I was using the heroin that I did have in my pocket while I was being interrogated. It's not like they have a 24-hour surveillance on you. This allowed me to continue using heroin. I was constantly feeding to maintain that high.
When detectives would leave the room, Marlo sniffed heroin from tiny bags hidden in the coin pocket of his jeans. Afterwards, he ate the empty bags to conceal his drug use from police.
Marlo got incredibly paranoid, and he wouldn't answer questions out loud. They gave him a pad and a pen, and Marlo would write his answers out, rip it out, show it to the detective to read, and then he'd eat the answers. And then at one point in time, Marlo curled up in the fetal position under the table. The detectives thought there was nothing wrong with that behavior. They saw no reason to question whether or not Marlo was under the influence of any drugs or alcohol.
When Wright began to confess, he wrote what he wanted to say on a piece of paper, and then he ate the piece of paper, which sounds weird, but if you're trying to prevent a permanent record being made, it makes sense. The other thing he did was try to sleep while handcuffed to a metal table in the interview room. And any police officer has seen that behavior dozens of times. If you want to sleep on the floor, you're going to have to adopt a curled up position. There is nothing unusual about it.
The Detective Mayfield was asked the question, well, do you believe Mr. Wright was intoxicated? No. You didn't notice anything that was going on from the eating papers to the various different things that I was doing. He didn't believe that anything was wrong with that.
We did observe Jermaine do certain things, write stuff on a piece of paper, eat that. We did not look at this as abnormal behavior. It's very hard to talk about killing someone, let alone confessing to killing someone.
Jermaine, do you understand the statements from the videotape? Yes. Okay.
What looked like innocuous behavior on the tape was actually evidence that Marlo was spinning down into withdrawal. On the videotape, Marlo would do this thing where he would scratch himself. That's what heroin addicts do. They start to itch. Marlo was sniffling all the time. It is a very common sign of heroin withdrawal. All he was concerned about was getting out of that room. This man is severely impaired. You cannot believe anything that man said in that tape.
At a 2009 hearing in front of Judge John Parkins, Moreno argued that Marlo's flawed confession warranted a new trial.
Judge Parkins was a new set of ears and a new set of eyes, who not just looked at what the state was saying, but he looked at the overall case.
Judge Parkins was very, very troubled by the fact that Marlo was in fact high at the time. And then he hears the evidence about Marlo's behavior at the time of the confession. And then he learns that there's no fingerprints, there's no DNA, there's no eyewitness testimony. There is nothing other than the flawed confession that links this man to his death sentence.
Marlo waited over 2 years for the court's decision.
Ultimately, Judge Parkins wrote a 100-page opinion, and he granted Marlo a new trial. We were ecstatic.
I've known Judge Parkins for a long time, and he is a brilliant lawyer, and he was a dedicated public servant. But that doesn't mean that he wasn't very wrong in this case.
I wanted to show different as to what happened at my first trial. And we was preparing to go to trial, ready to go to court with lawyers that investigated the case from bottom to top, because I wanted to see justice.
But Judge Parkins would not have the final word. The state appealed his decision to a higher court, and Marlo's shot at a retrial was denied.
I've never seen Marlo angry until that moment. He basically had his life hanging right in front of him, and it was yanked away.
Nobody that's innocent should be sentenced to die. Nobody that's innocent should have to spend 24 to 25 years of their life incarcerated. I missed the opportunity to watch my kids grow up. I missed spending time with my family. I missed the freedom.
After 2 decades on death row, Marlo had watched 15 fellow inmates make the walk to the death chamber.
These guys were my brothers. And you know they're not gonna come back. The end of my friend, of my brother. I started thinking that being as though I was the longest on death row, my time is about to come.
While he fought to save the life of his client Marlo Wright, defense attorney Jim Moreno took a closer look at the state's case, starting with a jailhouse snitch who had testified against Marlo.
At the first trial, the state called a man named Gerald Samuels to testify against Marlo. And he was a guy who was in jail who told the state that Marlo had made incriminating statements about his role in the case. My experience is that they bring in jailhouse snitches usually when their case is exceedingly weak.
Samuels, who was doing time on a drug charge, said Marlo had bragged about committing the murder. But this wasn't the first time Samuels worked with prosecutors.
When I asked that witness, did you make any deal with the state? He said no. And the state stood up and said, we've not given him any benefit. But ultimately, somehow, he benefited from that, I'm sure.
When Moreno investigated, he learned there was more to Samuel's deal.
There were letters from Mr. Samuel's lawyer claiming that he had some kind of agreement and that he wanted the state to honor the fact that he helped them It was a great piece of evidence. If I had been the defense lawyer, I would have wanted to use it to try to challenge his denials.
At the time the case was tried, we did not know that Gerald Samuels had previously been a police informant in a completely unrelated case. There were no computers that were keeping track of these things. Should that information have been given to the defense? Oh, absolutely. But we didn't know about it.
Combing through police reports, Moreno found another intriguing detail. On the same night as the Highway Inn robbery, an eerily similar crime had taken place.
About 45 minutes before the Highway Inn was robbed, there was a liquor store not too far away called the Brandywine, where two young African-American males entered the store and tried to rob the clerk. And the clerk fought back. A gun was pulled, and these guys fled the store without firing a shot or getting any money, and they never got caught. Those assailants who tried to rob the Brandywine fit the descriptions of the Highway Inn. Maybe they're the people who are responsible for the death of the clerk at the Highway Inn, not Marlo. There's your alternative suspects. That was an important piece of evidence that was never disclosed to trial counsel, never.
The details of that robbery were in the Wilmington News Journal. They were publicized in the newspaper at the time. But it was always unclear as to whether the defense had been given the police reports, so the assumption is he didn't get it. The two liquor stores are relatively close together. The suspect description was generally consistent, two black males, one being taller than the other, and the gun was described as a handgun. But, you know, that's not much.
On November 12, 2013, Moreno and his team went before the Delaware Supreme Court to argue that prosecutors had withheld multiple pieces of evidence from Marlo's defense team.
What the court ultimately found was that Marlo was entitled to a fair trial, and he didn't get one. When the court finally did rule in our favor, we were ecstatic. We felt like we'd come back from the brink and had pulled this off.
On May 19, 2014, the court granted Marlo a new trial. But the defense pushed further, asking to suppress the confession and end Marlo's case.
Our hope was that if we got the confession suppressed, then the case would be over.
Judge Parkins agreed.
At my first trial, they used my false confession against me. There was no blood, there was no gun, there was no eyewitnesses. There was no evidence.
Judge Parkins had a liberal agenda. I couldn't see any reason why he was attempting to toss out this videotape. So now we have the possibility, without the videotape, that Wright's going to be a free man.
We were hanging out at the Smyrna Diner, waiting for a call from the prison because they were going to release him. We drove over to the prison, and Marlo came walking out. That was really cool. It was really cool to see Marlo and his mother hug for the first time in 20-plus years. And that was a pretty special time. She got her kid back. He went back and lived with his mother in Wilmington, and he got a job within 2 weeks of being out, and he worked the entire time.
You know, you appreciate the smaller things in life. You go outside when I want to go outside, or there's no chains, no shackles. Take a shower when I want to take a shower. Go see my family when I want to go see my family.
He was supporting his mom. He had kids who were quite young when he went into prison, so he reestablished relationships with them. I think a lot of people in those situations may have collapsed with the pressure of being released after all those years, but Marlo did amazingly well.
While the state had dropped the charges against Marlo, the courts had not ruled him innocent. Prosecutor Steve Wood believed the case could be retried if he could get the confession readmitted as evidence.
There was a possibility that he was intoxicated, but based upon what I can see in the videotape, his responsiveness to questions, the fact that his answers made sense, the fact that he clearly understood the questions, he knew what he was doing when he said, "Yes, I'll talk to you." Wright didn't just say, "I was there and I did it, and society's to blame." He provided details. Wright said that the crime began with Lorenzo Dixon coming to him and saying, "There's an old man working alone in the liquor store at the Highway Inn."
He told me that he had went down to the highway end and seen that the man was there by himself.
Now that's consistent with an employee of the Highway Inn who said somebody came in and looked like they were casing the joint.
When you went inside, who did you see?
The old guy.
What color was he first?
He's white.
He's a white guy? What color was his hair?
Red.
He described Phil Seifert as an older white male. True. Wright also said that Phil Seifert was balding and had a bald spot on the back of his head. True.
His hair was like going back like a little bald spot or something like that.
And there's also the fact that Wright correctly described the location Mr. Seifert was shot.
Where did the shot hit him now?
Like back here somewhere.
Is that where it hit?
Yeah.
All of these years later, we've never heard a convincing explanation from anyone as to how he'd get all of those details exactly right if he wasn't there and wasn't the murderer himself.
When the detective is in an interrogation like this, they might not recognize how much information they were unintentionally providing Marlo during this time.
To analyze Marlo's confession, his defense team hired former homicide detective Jim Trainum.
We're not aware how contamination occurs. It's really hard to see if you're the interrogator. When I looked at the final confession on videotape, one of the things that stood out, a lot of the details that he was given, if he didn't quite get them right, they would attempt to get him to change his answer to fit what they believed to be true, such as the timing of the murder.
What time did this happen?
Say about 11:30, 12.
Marlo is way off as to when the murder actually occurred.
According to police records, Philip Seifert was shot between 10:30 and 10:45 p.m.
Could it have been earlier?
Could have been.
Also, Marlo said that when he shot the victim fell to the floor.
What happened to him after he got hit? Did he fall to the floor?
Yeah.
He fell to the floor?
But the victim actually was slumped on the counter and fell on the floor much later. So the detectives try to correct it. They're asking him, well, did he stand back up?
Did he try and stand back up?
I didn't know.
They were telegraphing to him, this is something else that we need to incorporate in the story. It's not right. Says that he shot the victim once.
Do you remember how many times you pulled the trigger?
Once.
The detective challenges him, are you sure?
Are you sure it's just once?
Yes.
That is a very common form of contamination. What the detective is doing is telegraphing to the suspect, you're getting it wrong.
You know what caliber the gun was?
38.
Ballistic reports found that the bullets came from a .22 caliber gun.
If there's huge inconsistencies there, that's a huge red flag. That's what we saw in Marlo's case. If I was a supervisor who was reviewing this investigation, I would have a difficult time accepting Marlo's statement as being reliable without a lot more work being done.
There was tactics that were being used by the police that an intoxicated mind would not understand. Things are constantly being repeated. And when they're constantly being repeated to you, then you begin to think that you really did that. The hours going by, they're long hours, you're tired, then things start coming out. Because you done heard it many, many times from these officers that sat across the table from you.
In the 90s, a lot of times they didn't actually videotape the entire interrogation from start to finish. They only did the final confession after all those hours of interrogation. So you don't get to see what led the person to confess. When they're saying that all they do is tell the person, just tell us what happened, and then it takes them 6 hours to tell them what happened, somebody's lying. And I don't think it's a suspect.
There's never been any talk of coercion. Nobody has ever said that happened, and that includes Jermaine Wright. The defense has insinuated it. An insinuation by a lawyer is just that. It's not evidence. Any average person who watches that confession would be absolutely convinced that Jermaine Wright was talking about a murder that he committed himself. Judge Parkins, on 2 separate occasions, tried to prevent us from using the confession, a reasonable person viewing those facts might have concerned that Judge Parkins had made up his mind about the defendant's guilt or innocence, which a judge may not do.
On January 11th, the Delaware Supreme Court refused to suppress the confession and reinstated the murder charges against Marlo. The court also removed Judge Parkins from the case, assigning a new judge for Marlo's retrial.
I got a taste of freedom for 10 months. And then I got a phone call from federal defenders. I got some bad news. The Delaware Supreme Court reversed your case. They're setting up a time for you to turn yourself in for a retrial.
Having been on death row for over 20 years and getting released and starting your life again, and then suddenly, bam, it was cruel.
Jermaine Wright, a former death row inmate who was freed last year, is turning himself in today to Delaware State Police. This comes after a Delaware Supreme Court ruled that his videotaped confession can be used by prosecutors at his retrial.
I'm innocent. Something needs to be done. I did 24 years already for something I didn't do. Now I gotta go back in for something I didn't do. I done gave him enough time.
We eventually recruited a New York law firm to represent Marlo. They came in with a very large team. They were awesome. They believed in Marlo's innocence. They were gearing up.
We were now faced with the prospect in 2016 of retrying a case that occurred in 1991. That's not easy. Criminal cases do not get better with age. They fall apart. The memory of the witnesses begins to fade.
Had we had the evidence that they had, then we would have been able to argue a different case. How would you take me to trial? They knew that they couldn't win. This is why they come up with the plea.
In September 2016, prosecutor Steve Wood decided to make Marlo an offer, plead no contest, and avoid a new trial.
A defendant who is pleading nolo contendere is essentially saying, I admit that you have the evidence necessary to prove my guilt beyond a reasonable doubt, but I will not answer the question of whether or not I am, in fact, guilty. I admit you can convict me, but that's all I'm saying.
While taking the plea meant Marlo could leave prison, the criminal charges, including murder, would remain on his permanent record.
When it was presented to me, I said, are we going to trial? And they said, well, we're going to give you time to think about it. Came back a week later, I said, we're going to trial. But they never threw the false confession out. Who's to say that 12 people would not think the same? Having a taste of what freedom is after such a long time, you begin to weigh all the things that you will have to go through again versus being free.
On September 12, 2016, Marlo accepted the state's offer.
He walked out of court that day, a free man. He went home. And it broke my heart that he had to enter a plea like this. But it ended this 24-year saga for him.
The Jermaine Wright case is the only case that I can recall where all of the evidence of an individual defendant's guilt came from his or her confession. And that is, at least in my experience, extremely unusual, unprecedented. But let's put the cards on the table. The only way that Jermaine Wright could have known those things, if he wasn't there himself, would be if the police told him what to say. Jermaine Wright has never himself said that, not once.
Confessions have to be like any other evidence. You have to evaluate them for the reliability. If you have no other evidence but a confession, and that confession cannot be proven, then it's not good enough.
Marlo came so close to being executed. There was no DNA, there was no fingerprints, there was no eyewitness testimony. They had no ballistics. There is nothing other than the flawed confession that links Marlo to his death sentence. Your job as a prosecutor isn't to convict, it's to seek justice. So if you have a confession that doesn't line up, I think you send your detectives back out to the streets and try to figure out what really happened. Marlo's case is a travesty because they didn't bother to fact-check Marlo's confession. They dropped the investigation.
In this particular case, there are two fractured families. One is the victim and one is the suspect. The family of Jermaine Marlo Wright went through a trial. Royce Seifert's family went through a trial. We all went through a trial.
People talk about closure. There's no closure in this one. We still do not have justice. On our side of the equation, our father is dead. How do we make this right? Let somebody go free? I don't think so.
I'm sorry that they lost a loved one, but I'm not the one that was involved in them losing a loved one. I understand that they're angry, but they're angry at the wrong person.
On August 2nd, 2016, 1 month before Marlo was released from prison, the Delaware Supreme Court ruled capital punishment unconstitutional.
My hopes for the future is that I can be pardoned and that I can move forward. I've been working for a concrete company. Then I started my own lawn care business. I'm pretty much working 2 jobs and maintaining 2 jobs. It's busy, but it's going well. I believe that I can live a life after incarceration to be an example that even though the situation was harsh, that I am able to maintain as a productive citizen in society despite what I was being portrayed to be. I want to enjoy life that I couldn't, that they took from me for 24, 25 years.
On this episode of Death Row Stories, a drug deal in Texas turns deadly.
They were ambushed. They were massacred.
And a 17-year-old receives the ultimate punishment.
I believe a life for a life. I wanted justice for my son.
But when fateful mistakes are revealed,
they said the bullet was from his gun, and all of that was false.
A condemned man fights to save his life.
I was not his killer. I don't even remember his face. But he was dead. And I was going to die.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
Yeah, in the early 90s, there was a lot of murders in Houston. And there was a lot of drugs. Everybody, like, either they sell weed or they sell cocaine, crack. They would find people dead, getting killed over drug deals.
Among the victims of Houston's 1990s crime wave was a 19-year-old named Imaid Rasool. On May 14, 1992, Imaid stumbled into a Houston emergency room with gunshots to his face and foot. Police learned he'd been caught in a shootout in a nearby park, and that a young man named Adonias Collier may be dead.
Officers get to the scene. They find Adonias. There's a huge hole in the side of his head. They find an intact .25 caliber bullet and a small bag of cocaine. You don't have to be a genius to figure out when there's a bullet and there's dope and a dead body, it was some sort of a dope deal gone wrong. Houston, it's just always been a violent city with a lot of guns. But Blowing somebody's head apart is an extraordinary crime.
When they told me that my son had got killed, my son, Adonis, I never would have thought it was going to be my child. I had him when I was 17 years old. He was very, very sentimental and a loving person. That night, we had dropped him off at his apartment, and we were downstairs laughing and talking, and I remember holding him, you know, and he left. That was my last memory.
Police soon learned that Adonis and his friend Imaid had gone to the park to cut a drug deal. There, they met up with two men, 17-year-old Nanon Williams and 22-year-old Val Guevara.
2.5 weeks after the shooting, Val lawyers up and surrenders himself. They make an agreement with him that he's going to receive a 10-year sentence for investing in a dope deal, and he's going to assist the prosecution.
This was supposed to be just a straight-up narcotics transaction, is that correct?
Yes, sir. Cocaine was crack cookies. It was, I think, about 5 ounces for $4,500 to $5,000. And Marlo said that's all. Adonis and Nanon was to my right. And then I saw Marlo, let me see the dope. I chested one of them, and that's when the shooting started.
Val gives a graphic description of Nanon shooting Adonis with a shotgun.
And Nanon said, no witnesses. And he pulled the trigger. Then I just saw some feet fly in the air.
Nanon had arrived from LA, and while there were 3 felony warrants for him in California for 2 robberies and a police chase, he gravitates somehow to Val Guevara's apartment. Nanon tells Val, you know anybody who can sell us dope? And at some point, he decided to turn a dope deal into an aggravated robbery, capital murder. He was about as dangerous a human being as you would ever encounter.
3 months after the shooting, Nanon Williams was arrested in Los Angeles. In July 1995, he faced the death penalty at the Harris County Criminal Court. Vic Weisner prosecuted the case.
I've tried about 300 felonies, but this is a horrific case. There's no evidence Adonis or Imaid were armed. They were ambushed. They were massacred. It was a case very deserving of death.
Adonis's mother watched the trial from the front row.
Nanon was just a big, mean-looking dude. He was a real angry kid. I wanted justice for my son, Adonis Collier.
Survivor Imaid Razul took the stand, testifying that he and Adonis had gone to the park to sell Nanon and Val drugs. Just a few minutes into the transaction, Nanon suddenly started shooting.
Imaid testified that Nanon smiled at him, produced a .25 caliber weapon from his waistband, and shot him in the face.
Weisner argued that after shooting Imaid, Nanon then shot Adonis with his .25 caliber pistol and a sawed-off shotgun. A state firearms expert confirmed that the bullets found in both Imaid and Adonis came from a .25 caliber gun.
We've never recovered Nanon's weapons, the sawed-off shotgun and the .25. But it was a very strong case overall.
Val's girlfriend, Elaine Wynn, who rode with some of the men to the deal, testified that she saw Imaid and Val emerge from the park. Moments later, a shotgun blast tore through the night.
The only 2 people left at the dope deal were Nanon and Adonis. And unless Adonis committed suicide and Nanon stole the gun after the suicide, it was Nanon who blew Adonis's head apart.
Nanon's defense argued that none of the eyewitnesses could be trusted because they knew each other. But the jury's decision was swift: death by lethal injection.
When the jury sentenced him, he got lightheaded, and the judge said, get him up, stand him up. I think he was just shocked that he had got the death penalty. I felt relieved because I believe a life for a life. I do.
And they said, Nanon killed somebody. And I was like, he killed somebody? Selling drugs, I'm pretty sure I've sold drugs. Back then, it was just everybody just trying to make some money. But they're just going to kill now.
I was a kid. I didn't know Adonis Collar. I was not his killer. I don't even remember his face. He was dead, and I was going to die. As a child, I didn't know a single black male who hadn't been in prison. I looked at prison as a badge of honor, as stripes, as street cred. So my cultural values, they worked against me instead of for me.
Nanon Williams grew up in Southern California in the 1980s, where crime and drugs were a way of life.
I raised Nanon in the inner city of Los Angeles during a rough time. There was a lack of jobs, a lack of education. The drugs were rampant. It was a way out of poverty. Nanon was very adventurous, very smart. He always defended the weaker ones. Both of his fathers, biological father and stepfather, they were drug dealers, but they were not violent men. They were trying to support the family.
I learned things from my father, how to survive in the streets at a very early age. It was a culture where violence is respected more than being a good person. If my father had had a computer store to teach me a computer trade, perhaps I would have been a computer technician.
Nanon's stepfather ran a sizable drug operation. In 1985, he drew the attention of law enforcement.
It was 77 feds. They broke up our entire house and arrested myself and my husband and took all of my children in custody. That following February, Nanon's father was killed.
Nanon's mother raised him and his 3 siblings alone in South Central LA.
I was in nursing school and I was on welfare. Nanon was always trying to step up. And he started selling weed. And I told him, Nanon, don't do this. You see what happened to us.
In my mind, I needed to contribute. I wanted to be the man of the house. That led me to selling drugs. I felt I needed a gun for protection. You become comfortable doing things you shouldn't. And I became one of those kids.
When Nanon was 17, his path turned violent.
It's a Sunday afternoon. An elderly couple in their mid-60s gets home. 3 young men walking by ask, could you give us some water? One of the men has a gun. They duct tape and gag both of them. And they're stealing valuables. They torture them. There was one fingerprint that led to one suspect, and he led police to Nanon. Nanon, at that time, was an incredibly dangerous individual. There's no doubt Nanon was going to explode and kill somebody in the most horrific way.
A month after the home invasion, Nanon went to Houston with instructions to offload a drug haul. Nanon asked his cousin Troy for connections in Houston. Troy introduced him to 21-year-old Val Guevara.
At Val's apartment, everybody, we'd be there smoking weed, drinking. It was the hub for people to come buy drugs. I told Nanon, well, you probably could sell something to him.
Val Guevara had a dope house in an apartment, and I started wholesaling ounces of cocaine to them. They wanted more and more.
On May 13th, 1992, Nanon and Val arranged a drug deal with 2 men, Ahmed Razul and Adonis Collier.
We ended up going to this well-lit parking lot. We got out the vehicle. I was with Ahmed Razul the whole time. Somehow, Adonis and Val ended up walking to a dark area in the woods. I remember them arguing, and you heard a shot. And when you heard the shot, he pulled out a gun, and I wildly fired. And he took off running, and then you heard a loud boom.
After the shotgun blast, Nanon says he ran back to the car and met up with Val, and that they fled the scene together.
Everyone's nervous and it's quiet. We stopped at the apartment, which was not very far away. I got out the car. After that, I never saw them again.
Nanon went on the run back to LA. He was arrested 3 months later.
When they said a murder, I thought I killed Ime Rasul. And in my ignorance, I also believed in the system. I became the target because I would not cooperate. And it led to ruining my life and my family's life.
At 20 years old, Nanon became one of over 400 inmates on Texas death row. There, he met fellow prisoner Anthony Graves.
The day that they were walking me to my cell for the first time, I remember one guard start screaming and shouting at the inmates. At the end of the hallway is this big old emblem that says, Texas Death Row.
Anthony Graves was exonerated in 2010. He became the 138th man freed from death row.
I seen inmates shank each other. I seen an inmate rape an inmate. That's how violent it can be.
When I arrived, I was 20 years old. It felt like the world was against me. I fought everything.
One day, I seen this big guy come in. He liked to wrestle in everybody. And in my mind, it's like, this big old bully, I'm gonna have to figure out a way to deal with this dude, right?
Death row was a battlefield. The tattoos that I got, they were a shield to tell you I was bad, I was tough. But that's not who I was. I was scared to death.
Nanon and I, we ended up walking one day, introducing ourselves. And I learned a few things about his case that was appalling.
Anthony realized that I wasn't a bully. I was angry. I was so angry from losing everything that I had.
3 years after his conviction, a new team of lawyers took on Nanon's appeals in 1998.
The state's theory was that the group went in the park to do a drug deal, except Nanon Williams pulls out his guns and starts shooting to commit a robbery. Unbeknownst to anybody in the park, they put on evidence from a ballistics examiner that that bullet that was taken from the victim's head was a .25 caliber bullet, which matched Nanon Williams's gun. But once we started digging into the case, we learned that their witness lied and that that ballistics evidence was false. The actual jurors would not have convicted him had they known the true nature of the bullet.
2 years after Nanon Williams landed on death row, his new attorney started looking into another person with an opportunity to have committed the murder.
After Valgavar was arrested, he's immediately charged with capital murder. His lawyer tells the police department and the district attorney that he's willing to cooperate, and every month the charge slowly gets reduced. So it goes from capital murder to conspiracy to sell cocaine to illegal investment.
Nanon had been accused of shooting Adonis with a .25 caliber pistol, as well as a shotgun. But neither weapon was recovered. Police, however, did find a third weapon.
Shortly after the crime, they searched Valgavar's apartment and seized Valgavar's gun.
Did you take any weapons with you?
Yes, sir. It was a .22 Dante.
And how many shots did you fire from your gun?
Me, I fired for one.
Who were you pointed at when you fired?
I ain't really down this direction, but you know, he was getting back up again.
Valgavar admitted that he fired his .22 Derringer. but said that he didn't harm anybody. For some reason, the Houston Police Department never tested Val Guevara's gun. It just seemed inconceivable that they wouldn't test the only firearm they recovered in conjunction with a capital murder.
Nanon's attorneys now asked to see the bullet recovered from Adonias Collier to determine whether it matched Nanon's .25 caliber gun or Val's .22. Independent firearms expert Ronald Singer examined the evidence.
When the bullet passes down the barrel of a firearm, it picks up markings that are considered to be unique for each barrel. When you have a suspect bullet, you test fire that firearm and compare it to that bullet.
It was a strong case against Nanon at trial. The Harris County firearms examiner assured the jury that that bullet taken from the victim's head was from Nanon's gun and not from Val Guevara's gun.
A competent firearm examiner can tell the difference between a .25 caliber and a .22 caliber bullet with the naked eye. A .25 caliber bullet is a larger bullet than a .22 caliber bullet. It wasn't until we got the evidence that they realized their error.
We made a mistake. The bullet in Adonias's head is not a .25, it's a .22. And in fact, we matched it to Val's gun. Any person believing the first ballistics identification would believe that the only person who ever shot anybody was Nanon. It's an inexcusable error, and especially in a death penalty case.
It's incumbent upon any defense lawyer to challenge each part of the state's case, and Nanon's trial lawyer did not do that in this case. And she explained that she was an ex-prosecutor. She knew the state's firearms examiner and thought he was competent and wouldn't really make a mistake.
The firearms examiner had an excellent reputation for accuracy, but everybody makes mistakes.
If we had known at trial that this bullet was from Val Guevara's gun and not from Nanon Williams' gun, how would the jury have seen the evidence?
With it now clear that Adonias had been shot by Val Guevara's gun, in 1998, Nanon's appeals team filed for a new trial.
At the time, Texas death row was overcrowded. We had over 100 men waiting to be executed. Our system has painted them as the worst of the worst. It can make you very bitter because you're being treated less than a human being.
I saw guys literally drugged from their cell because they don't want to walk to their death. It's hard to get that out of your mind. I wanted to show that they were people. And I started my own newsletter. It was called the Williams Report.
The Williams Report provided an intimate account of life on death row and profiled what Nanon perceived to be grave injustices in the cases of his fellow inmates. With the help of his family, Nanon distributed the Williams Report to a growing readership in the outside world.
Nanon, I always want to talk about something constructive. We could talk about politics, social justice. Nanon did everything he could to shine light on prison conditions, exposing the criminal justice system for what it was.
I didn't realize by interviewing other prisoners, I would delve so much into their lives. I was chronicling what took place on Texas death row. My writing, it became my sword.
Nanon was a warrior for a cause, and they tried to silence him. Now, we're all in isolation, but they also have a cell called a management cell, where it's just a steel door, you can't see anything, and that's why they would put Nanon.
I know what it's like to live in a cell so black. You can't see your own hand in front of your face. So it makes you wonder if you're alive. When you're trapped in your mind, the fears you have, the depression you have, the sense of loss, it becomes circular. For many people, it drives them to commit suicide. For me, writing allowed me to construct a new world. It gave me a sense of freedom.
In September 1998, Nanon received a hearing to argue that the state's faulty firearms testimony had unfairly influenced the jury.
How do you look at a case like this and think that the process worked? Because that's really the question is, do we have confidence in the outcome?
Prosecutor Lynn Hardaway argued against Nanon's appeal.
Capital murder is a big deal. We don't want there to be mistakes. We just started trying to talk to as many people who knew Val Guevara or Nanon Williams. In the offense report, there were a lot of references to a person who had driven Val and Nanon Williams to the scene. We interviewed a couple of different people at the Harris County Jail, and one of them gave us the name Patrick Smith.
Lynn eventually tracked down Smith, who said he'd driven Nanon and Val to the park that night. Smith also confided to Lynn that he'd seen who'd murdered Adonius Collier.
Patrick said that he could see what was going on very well, and that Nanon shot Adonius in the head with the shotgun. It was a stroke of luck that I found Patrick. The investigator for the DA's office at trial had never been able to locate him. He was living in California. Probably he didn't really care to be found.
Patrick claimed he had only recently met Nanon, Val Guevara, and Val's girlfriend Elaine Wynn when he agreed to drive them to the park the night of the shooting.
Patrick Smith was sitting in the car with Elaine Wynn, and they're kind of talking back and forth, and then they hear shots. He pulls up the car to see better what's going on, and he saw Nanon standing over Adonius with a shotgun. And that Adonius was still alive when Nanon shot him in the head. Regardless of a misidentification of the bullets, that doesn't take away from the fact that Nanon ultimately killed Adonius Collier.
The testimony of Patrick Smith is contradicted by the state's witnesses. Elaine Wynn says there's no way that Patrick Smith could have seen into the park and seen anything that happened, and she's sitting next to him.
Patrick testified he could see key events from his perspective in the park, and he said that the park was very well lit. I thought he was very credible.
Nanon's attorneys did not believe Patrick Smith was telling the truth. They turned to veteran investigator Richard Reyna for help.
They wanted to find out who shot who had a shotgun. The guy that could really tell me was Imad Rasul, the person that got shot and didn't die. If Nanon shot him, then he was holding the shotgun and a gun. So how could they make a drug deal? I went to see Imad. He says when they got out of the car, he walked with Nanon Williams. And then all of a sudden, Val disappears. So it was just the two of us. And I said, was Nanon carrying a shotgun? He says, no, he did not have a shotgun. Nanon Williams was wearing a very flimsy T-shirt. You couldn't have hidden anything in there.
Imad Rasul probably has the least incentive to lie in this case. And he is adamant that Nanon could not have had a shotgun.
Contrary to Imad, at trial, Val and Elaine had testified that Nanon entered the park wearing a thick jacket.
One of the real problems with this case is that everyone does have some sort of self-interest to lie. Val Guevara and Elaine Wynn were able to shape the narrative and the investigation. They're good friends with Patrick Smith. We find out later that Val Guevara had known him for years. The other thing that's very concerning about Elaine Wynn's testimony is that Elaine Wynn was sleeping with Val Guevara and had dated the deceased victim.
Elaine was angry that my son broke up with her. I think she set him up. You can't tell me that you jumped in a Jeep with some guys with some rifles and you didn't know they were gonna kill him.
Nanon was from California, hadn't known these folks so long. He was the only juvenile that was out there, and in some ways an easy target.
People deserve to know the truth.
Texas executes more children than any other government in the world. and we should hang our heads in shame when people accuse us of barbarism.
In the early 2000s, Nanon Williams was one of 31 juvenile offenders awaiting execution when lawmakers called on Texas Governor Rick Perry to abolish the death penalty for crimes committed under the age of 18.
The same things that make persons with intellectual disability less responsible for their acts apply directly to juveniles. The developing human brain is much more impulsive, and we don't think about the consequences of things, even the best and brightest of kids.
6 years into Nanon's sentence, the criminal court gave him new hope when it recommended he receive a new trial. It would be up to the Court of Criminal Appeals whether to grant it. Meanwhile, Capital Defense Attorney Walter Long, an expert on the juvenile death penalty, joined Nanon's team.
Nanon was actually a good friend of my former client, Napoleon Beasley, who was executed in 2002. Napoleon's case became a very prominent case in the national effort to abolish the death penalty for children. In Nanon's case, there was no evidence of any conspiracy to commit a murder, much less a robbery. This never should have been tried as a capital murder case. It is just not. Texas has a reputation as a pretty bloodthirsty state. Executions happen here on a routine basis.
I was labeled a monster. And looking at all the men die, I wanted to make my family proud. And I knew I couldn't do that through talking about my case. I could only do it through character, through sheer will to accomplish things that none of the men around me could.
Since arriving on death row, Nanon has published 3 books, including a collection of poems. He also earned undergraduate and master's degrees in literature.
I've lived an abnormal life, and I learned that I could just be honest and put the mistakes I've made on the table, and people will listen. My writing allowed me to be a contributing member to society, and that keeps me going.
Nanon at that time was a product of his environment, but then he was taken off of these streets, and Nanon discovered Nanon Williams.
In the spring of 2002, Nanon's chance at redemption was cut short. In a 1-paragraph order, the Texas Criminal Court of Appeals denied him a new trial.
The court gave no indication of its reasoning, so there was no way to determine whether its decision-making process was reasonable at all.
They simply said, we disagree with some of the fact findings and some of the legal conclusions, without specifying which fact findings or which legal conclusions.
The system is designed to push everything toward the execution date before there's been full and fair consideration of all the relevant facts. We have an authoritarian culture here.
In the wake of the court's decision, several of Nanon's jurors signed affidavits stating if they had known about the botched firearms analysis, they may not have sentenced him to death.
And I'm sure the jurors were very well-meaning, but if you let them read the testimony of Patrick Smith, I'm sure they'd be very confident that they did the right thing. Cases are retried all the time, but Nanon would be right back where he's at. You have my word on that.
After 8 years on death row, Nanon had exhausted all of his state appeals. Walter and Morris would now turn to the federal courts. But while preparing their appeal, they discovered that Val Guevara, in addition to firing the .22 caliber bullet that hit Adonius, was now changing his story.
From the very beginning, we've been asking for any statements that Val Guevara had made to the prosecutors while he was negotiating his plea. The judge finally agreed that the prosecution turned over this audio recording of Val Guevara that they took in August of 1998.
In his original statement, Val told police he'd been standing with a maid Razul, while Nanon was with the victim, Adonius Collier.
Did you ever see Nanon shoot the 25?
Or was
No,
it just...
I didn't see
Okay.
anything. And me and Adonis was talking and all this, and this just kicked off.
Okay. And so you took off and you turned around and shot. You
Right
busted
away.
2 cats, right?
Oh, shot once.
Just once, okay.
And so he admitted that he, in fact, was the one talking with Adonis Collier, and that Nanon was over to the side talking to Ahmad Rasul, which was different than his trial testimony, where he put Nanon with Adonis Collier.
It's astounding. The ballistics evidence establishes beyond a shadow of a doubt that Guevara shot Collier in the head and is culpable of some kind of a homicide. The state doesn't charge Guevara with capital murder. So something's really, really stinky there.
We offered Val Guevara an agreement before we knew the bullet was misidentified. Every criminal wants to get out of their situation. We basically rolled out a red carpet for him to do it when we misidentified the bullet.
In exchange for his testimony against Nanon, Val received a 10-year sentence. After 4 years in prison, he came up for parole.
We were always given a list of people eligible for parole, and I see the son of a gun's name. And I just wanted to let the Board of Pardons and Paroles know he got away with murder. Keep this SOB in prison as long as you can.
Vic Wiseman, my prosecutor, wrote a letter to Val Guevara's parole board stating that he knew Val Guevara lied at trial. But here I sit, convicted of robbing a man and killing a man, and I never said a single word to him.
Val was a horrible witness, and he escaped justice for a very serious crime. Has nothing to do with Nanon's guilt. There's no doubt Nanon blew Adonis's head apart with a shotgun.
There's no statute of limitations on murder, so they could possibly charge Val Guevara with Mr. Collier's murder.
Something's wrong with that picture. I think everybody should be doing life. Once you play a role, you should be held accountable.
As Nanon waited for word on his federal appeal, the highest court in the land decided to take a closer look at the juvenile death penalty.
During that time, Texas was continuing to set execution dates for child offenders.
This is a horrific case, and I'm not embellishing. Nanon Williams is a very dangerous individual, and with the exception of his age, I'd say a no-brainer for the death penalty.
Since 1990, only 7 countries other than the United States have executed juvenile offenders: Iran, Pakistan, Saudi Arabia, Yemen, Nigeria, the Democratic Republic of Congo, and the People's Republic of China. Since then, each of these countries has either abolished or made public disavowal of the practice. It is fair to say the United States now stands alone in a world that has turned its face against the juvenile death penalty.
Good evening. The Supreme Court today declared that the execution of juvenile murderers is unconstitutional. That ruling overturns the death sentences of 72 murderers who were under 18 when they committed their crime.
I think there's a strong probability Nanon would have been executed if the Supreme Court hadn't barred the execution of juveniles. The Supreme Court recognized that juveniles have a different level of culpability when they're 16, 17 years old. They're not making rational decisions all the time.
I don't make any apologies for seeking the death penalty. I think it was the right thing to do. When you change the law from 17 to 18, why not make it 19 or 20? Unless it's based on empirical evidence, it's just a number picked out of the air.
In Nanon's case, it's unclear exactly why the shooting started. This was a bunch of young people in a park doing a drug deal, and if someone gets spooked, you can see how just it immediately goes out of control.
At 17 years old, you know right from wrong. When they took him off of death row, I want him to serve the rest of his life in jail. He's not a person that you want back in society. I don't think he's changed.
Nanon put himself in this position, and he can't get around the fact that he blew a hole in Adonis Collier's head and killed him. Even though not the cleanest proceeding, I think ultimately the right decision was made, and I think Nanon Williams is where he should be.
I feel bad I even introduced him to these people. I didn't think it'd be like this. Yeah, I feel guilty about it every day.
In 2012, the federal courts rejected Nanon's appeal. He is now serving a life sentence.
I sold drugs. I owe something for that. Although I didn't kill Adonis Collier, I'm responsible for the actions that occurred that night. I wondered, in a parallel universe, if I could have been him or he could have been me. More than anything, I remember his mother and my mother, two women grieving a loss. And I've never forgotten that.
Nanon is not a danger to society. I want him set free. He wrote one poem to me, Dear Mama, from a quiet sleep in the dead of the night, I wake with a single tear, clear and cold as it ran down my face, because I thank God that you care. Even when I stand alone and no one is there, sometimes, not often, I wish I could turn back the hands of time and make myself a little boy again.
I do believe in second chances because I do know there's a good and bad that works in all of us. It's the choices we're making. I watched a young man come as a bully, turn into an intellectual, writing books, always trying to help other people on their cases. How is it that society don't think people can change?
Nanon Williams might have reformed. I doubt it. He's a social justice fantasy.
My sentence said I was a waste of time. So I made it a point to reach for higher education. I spend my days here teaching. It's the only thing I have to give. I do these things to prove that even people who are judged the worst of us can become the best of us. Life is still moving, and I'm a part of it. As long as I'm breathing, I'll win.
On this episode of Death Row Stories,
we had a stabbing homicide.
A brutal murder in a Phoenix bar.
She was on her back. Her clothing was strewn around the restroom.
And a gruesome signature left at the scene.
We thought we had a murderer with a disfigured tooth.
Crooked teeth put bite mark science on trial, and an Air Force veteran on death row.
There was no way that Ray's teeth could have made those marks.
The blood didn't match, the fingerprints didn't match.
They hid this evidence until the very last minute.
They wanted the death penalty. They were going to do everything they could to make sure it happened.
This was our justice system, but it turned out that this system ain't about the truth.
There's a body in the water.
He was butchered and murdered.
Many people proclaim their innocence.
In this case, there are a number of things that stink.
This man is remorseless.
He needs to pay for it with his life.
The electric chair flashed in front of my eyes.
Get a conviction at all costs. Let the truth fall where it may.
It was December 28th, 1991. Kim Ancona was a single mother. She had just had a wonderful new thing in her life. She was a bartender who had just been made a manager of the CBS bar in Phoenix, Arizona.
The CBS Lounge was a nice bar to go to. It was in a strip mall in Phoenix.
I worked literally right behind the bar she was working at, so I would stop on my way into work or on my way home from work, stop in and hang out with her, have a couple of Cokes and play darts. I would see her every day.
That night, when we were getting ready to leave the bar, for Kim closing up, we asked her if she needed any help. She said no, that she was going home.
She had called me and asked me if I could find her a bag of weed. And I told her I would try. And I called her back later. I was unsuccessful, and she said that was fine. And that was the last time I spoke to her.
In the early morning hours of December 29th, 1991, the owner of the CBS Lounge arrived to open the bar.
The first thing he noticed was that the front door was open and had not been locked. So he went in. Everything looked like it had been cleaned up, but he noticed that Kim Ancona's purse was on the bar. Then he went into the men's room and saw her body.
I got a call to roll up to 17th Avenue in Camelback, which is where CVS was. We had a stabbing homicide. There could have been sexual assault.
She was on her back. She was naked. Her clothing was strewn around the restroom. It had been cut off her body. She had multiple wounds around her neck, around her body.
Kim Ancona had been stabbed from behind multiple times with a kitchen knife. Detectives found the murder weapon in the bathroom trash can.
The knife was actually bent significantly. Later at autopsy, it was determined that probably occurred when the knife hit bone, which indicates somebody very powerfully stabbed her. So this was just a horrific crime.
I was riding my 10-speed to work and cutting through that parking lot, and I saw the yellow tape around her car. And as I rode up, I wanted to see what was going on because, of course, my mom's car is covered in tape, and one of the detectives took me aside, and he said that my mother is no longer with us and that she's been killed. I was in shock. I couldn't believe it. To be honest, I'm still in shock, It's probably the worst thing that I could have ever heard.
At the crime scene, police examined Kim's body and discovered strange marks on her torso.
They saw on the body lesions that looked like bite marks, both on her neck and on her left breast. So they called a dentist who worked for the medical examiner's office, Dr. John Piakis.
They were distinctive bite marks in that the teeth didn't really line up the way you would see them on your Crest commercial or whatever. So we thought we had somebody with a disfigured tooth.
Police began questioning the bar's patrons and employees. One name kept coming up.
Several people that we talked to got the name Ray as somebody that she had been out with.
Some of Kim Ancona's friends told the police that Ray was a friend of hers. They had suggested he's like a boyfriend. So they thought, well, we're going to go talk to Ray.
35-year-old Ray Cron lived just a few blocks from the CBS Lounge. A mailman with no criminal record, he was a regular at the bar.
I had heard his name before because my mom had a little bit of a crush on him. Thought he was a handsome guy. The one time I did see him at the bar, my mother had asked him to substitute on her dart team. At the end of the dart tournament, she asked him to pay the entry fee, and he got really upset. He raised his voice and pretty much stormed out of the bar.
I went over to his house. It's really not far from the bar. He responded to our questions. The key, as far as we were concerned, was he didn't have perfect teeth.
Cron denied being in a relationship with Kim Ancona, and his roommate told police he had been home all night. Police brought Cron to the station and collected samples of his hair, saliva, and blood.
And at the end of the interview, they asked Ray to bite into this section of the styrofoam paper plates. And then they took that to Dr. Piakis, and Dr. Piakis said, well, that's consistent with the murderer.
Police took impressions of Cron's teeth to create a plaster model. When they compared them to the bite marks on Kim's body, they appeared to line up. A day later, on New Year's Eve, Ray Cron was arrested and charged with kidnapping, sexual assault, and murder.
I was 14. It wouldn't have happened. I believe it was a day or two before the funeral. I had heard that on the news they had caught somebody, and they said his name. It didn't help very much, but I had some relief that the person who did it was going to be punished.
Cron's court-appointed attorney suggested he plead guilty and take a deal. He refused.
He wasn't going to take a deal. He said, I didn't do it. And I will tell you that in the 20 years I was in homicide, I heard that every time. I didn't do it.
Ray Cron's trial began on July 29, 1992. Veteran prosecutor Noel Levy was determined to seek the death penalty.
Noel Levy was a career prosecutor who had a very good reputation, had done a number of very high-profile cases. He had a background in the military. He was a military intelligence officer.
Levy would focus his case on the bite marks left behind by the killer. His star witness was Dr. Raymond Rawson, a dentist and Nevada state senator. On the stand, Rawson produced a compelling exhibit, a video comparing Cron's teeth to the marks on Kim's body.
I had never seen a videotape of that type ever used by anyone else. It took hundreds and hundreds of hours to create that video. He used 2 cameras and then he put the pictures together, and that videotape was very convincing.
Kim's oldest son, Chris, sat in the courtroom.
It was really hard because I was only 18 years old. To be honest, I shouldn't have been in there. They shouldn't have allowed me in there. There was just things that I shouldn't have heard, the bite marks, shouldn't have seen any of that. The whole case was very traumatizing.
After an 8-day trial, the jury delivered their verdict. Ray Cron was guilty of kidnapping and murder in the first degree. He was sentenced to death.
It took the jury a little over 3 hours to find me guilty. You kind of sit there like you're watching a tennis match, and you're actually being the ball that's being hit back and forth. Everything that I stood for and believed in, the justice system was gone.
On December 3rd, 1992, Ray Cron entered death row at the notorious Casson prison in Florence, Arizona.
The death row in Arizona is complete isolation. You have no physical contact with other inmates. The cell was about 6 by 8. I could stand in the middle of it and just about touch the walls. And then out a small window where you could look out across the desert. And that's it. You were in your cell. You got 2 phone calls a month.
The atmosphere in Maricopa County in 1991 was a very law and order oriented judicial system. There was a lot of pressure on judges in particular to get these trials done, and they wanted the death penalty. They were going to do everything they could to make sure it happened.
To visit her son, Ray's mother, Carolyn, traveled 2,500 miles from Pennsylvania.
The experience of visiting someone on death row when they bring them into the cubicle on the other side of the glass was a very, very hard thing to see.
I remember seeing the look in my mom's eye I'm shackled at the waist and ankles, and I'm shuffling in a jumpsuit. And how do you let your loved ones know that I'm okay, I'll be okay, you know, it's all right. I grew up in Dover, Pennsylvania, farm country. I went to the same high school my grandparents went to, the same church my great-grandparents went to. We enjoyed that outdoor country life.
Ray was the most pleasant, happy-going, easy to raise child. Always a lot of fun. All the way through high school, Ray was involved in activities and scouts and church and things.
After high school, Ray signed up for the Air Force. He was stationed in Savannah, Georgia, when a car accident left him with severe injuries.
I woke up in the hospital, my mouth wired shut, I had a broken jaw.
After that accident, Ray's appearance had changed some because his teeth had been badly damaged and his jaw had been broken. And so when they wired it together and it re-healed, his teeth were crooked.
I remember how painful it was having a broken jaw. I'll never forget that wired shut mouth and the pain that brings around your teeth and gum area.
In 1980, Ray moved to Phoenix and took a job with the post office. On the side, he was an avid dart player, and he often stopped by to compete at the CBS Lounge, sometimes with bartender Kim Ancona.
Kim was a bubbly, outgoing person. She worked there, and it turned out then that she also had a dart team.
My mom was the captain of their dart team, so she was very into darts. And we used to play a lot of darts together in the bar and at home, but I could never beat her.
She was a nurse, but she saw kids deteriorating, seeing some pass away, and it was really affecting her, so she stopped doing that to be a bartender.
My mother was very hardworking. Family was always first. She did whatever she could to keep a roof over us, keep us fed.
She would come home from work and sleep for about 3 or 4 hours and then get us off to school. She had that nurturing heart, and she was hilarious. She was the life of the party.
In the early 90s, my mother was going through a divorce. My brother and sister were staying with our stepfather because I wasn't home anymore, and she had lost her home because of the divorce and all that. She was trying to get back on her feet.
She was happy to get all these hours working at the CBS Lounge because she wanted the money so that she could have her own house with her kids.
She wanted to get her family back together, and that's the move she was making when all of this happened.
For 2 years, Ray Cron sat on death row, while his mother Carolyn fought for his case. The family eventually brought on defense attorney Christopher Plourde.
I first met Ray Cron in June of 1994. I traveled to death row in Arizona, and I interviewed him for a number of hours.
Chris wasn't a man that seemed like just be going through the motions and asking routine questions, because this was a man that cared.
Early on, I got the notion that Ray was, one, not the type of person that would do this, but I walked out of there and he was just like one of my brothers, you know.
That man from that day on was one of my strongest defenders and fought for me the whole way through.
When he dug into the case, Plourde realized the main evidence against Ray, Dr. Rawson's bite mark video, had been revealed to the defense just 2 days before trial.
They hid this evidence until the very last minute, when of course there was not time for the defense to do any kind of counteraction.
Why in the world would the state try to get into evidence a videotape that had been disclosed but 2 days before trial?
The appeals court said, "Are you kidding me? You have got to disclose to the defense what evidence you have."
After nearly 3 years on Arizona death row, Ray Cron was granted a second chance to prove his innocence. But as attorney Chris Plourde prepared for Ray's second trial, he found himself stymied by prosecutor Noel Levy.
I wanted to get access to the evidence from the police department. And Noel Levy objected to that. He would refuse to give me notes from the crime lab, access to the evidence. And then once he was ordered by the Supreme Court to give me discovery, he went to every interview and essentially knew that he was in for a long fight.
Among the evidence the state finally handed over were 17 hairs found on Kim Ancona's body. Of these, 2 came from an unidentified person, and another was never tested.
They said that some of them were Kim's, and others could not be ruled out as being Ray's. That wasn't even true.
The reality is when you look at the evidence hairs were from a person who was either Mexican-American, Hispanic, or American Indian. So Cron could not and Ancona could not have been the donors of those hairs.
Chris also received police files showing footprints recovered from the scene, matching size 9.5 Converse sneakers.
Ray Cron didn't have Converse shoes, and he wore an 11.
They basically reanalyzed the latent prints, and they came up with an opinion that the size was consistent with Mr. Cron, even though he didn't own those type of shoes.
Finally, blood collected from the crime scene tested as type O. Noel Levy said that matched Ray, but it also matched back to Kim Ancona.
You have to remember, in the early 90s, we knew DNA was coming, but it wasn't coming to Phoenix right away. We were still blood typing. They would be able to say that it was AB or O. Back then, ABO was about as good as you were going to get.
It was amazing the number of things that they did try to do a test on, but if it didn't match me, they ignored it. They're not looking for anybody else. They only wanted stuff that matched me.
Ray's second trial would begin on February 16, 1996.
Noel Levy's theory of the case was virtually the same as it was in the first trial. That Ray Cron was essentially the boyfriend of Kim Ancona, and that unless Ray Cron loaned his teeth to somebody, Ray Cron is the killer.
Noel Levy was an extremely effective prosecutor. Very tall, very persuasive, could mesmerize a jury, would make declaration statements that make them sound like they came right out of the Bible.
Levy argued that Ray and Kim had been romantically involved, and that Ray killed her in a jealous rage.
This boyfriend-girlfriend thing kept coming up. I kept telling her, look, I know her from the bar. That's it. She hasn't been to my house. I'm not her boyfriend.
Ray did not even know her last name at the time that she was killed. She was just Kim from the bar.
Daniel Miller, Kim's youngest son, attended the second trial and saw Ray in person for the first time.
For those 4 years, I built up a lot of hatred towards Ray, and to see him 20 feet from me, I wanted to jump over the wall and cause physical harm. I believed in an eye for an eye, and I wanted him to be put to death for what he did.
When it came time to address the jury, Plourde attacked the state's case piece by piece.
Chris proved that blood didn't match, the fingerprints didn't match, and they're eliminating all these things. So we really felt good about that.
The truth was coming out, but I was starting to feel positive about the system again. But it didn't take long to realize that they were serious about believing that I'd done it and were going to make sure that I was going to pay for this murder one way or another.
As Ray Cron faced the death penalty for the second time, he was facing off against a respected scientific field. Forensic odontology, or the science of bite marks, had come to prominence in the late 70s when serial killer Ted Bundy was convicted with the help of Dr. Norman Sperber.
Dr. Sperber was considered the leading forensic odontologist in the country, and he saw this evidence in Ray's case early on.
I ran into Dr. Sperber in San Diego in the courthouse, and then he asked me, he said, what case are you involved in Arizona? And I said, well, the Cron case, the guy's on death row. He was shocked. because he had concluded before the first trial that there was just not enough information there to conclude it was Ray's teeth, and that information was never given to the defense attorney.
Prosecutor Noel Levy eventually hired Dr. Raymond Rawson to analyze the evidence.
Noel Levy paid Mr. Rawson $50,000 to show a jury how these teeth marks matched. He created a video in a system that nobody understood, and this video was unbelievably convincing.
At the time, computer technology wasn't what it is today, but he was doing some image correction to make the comparison on these breast models and demonstrating how Ray's teeth made a match.
And he apparently was able to manipulate the images to, in fact, change the size of Ray Cron's teeth to match the bite mark.
To counter Rawson, Plurd called 3 top odontologists who testified that Ray's teeth were not a conclusive match.
He measured the teeth from canine to canine. There was no way that Ray's teeth could have made those marks. But in the video, it looked like they lined up perfectly. So I basically said Ray Rawson is a charlatan and a fraud, that he had no scientific method.
The state had also produced molds of Ray's teeth that seemed to be a match, but Plurd argued otherwise.
There was a video that was done of the police department examining the body of Kim Ancona.
They took the mold of Ray's mouth and they put it on her body. And they twisted this mold to fit into the marks on her body. They twisted and turned it, therefore possibly creating the match with Ray's teeth. Because, of course, this flesh is now dead, and they're not going to retain whatever you've done.
Then what they did is they took molds of the breast, and they used those in the video also to show that there was a correlation between Ray's teeth and the bite mark based upon the mold.
While the medical examiner's office denied affecting the evidence, presiding Judge James McDougall did find credence in other defense arguments.
I thought the defense, they did an excellent job of creating doubt. I came away from that thinking, well, that's not as clear as it looked when the state rested.
Now there was the bite mark experts that said it wasn't me. Saliva on the bite mark wasn't me. Hair wasn't me. Just so many things now to come out that never, ever came out in the first trial.
Ray's trial would last 7 weeks. It took the jury 3 days to render their verdict.
When the jurors came into the courtroom and had to face us that day, I had an uneasy feeling that they were avoiding looking at us.
The verdict was announced. It was all in slow motion.
First degree, we find the defendant, Ray Cron, guilty.
Jay just said guilty, guilty. Whoa, back up, wait a minute, what's going on here? This can't be possible. What are they saying? And I just couldn't believe it.
After all these weeks and days and hours, to hear that verdict is like doomsday. I mean, no, not all this, and here we are where we started.
What more evidence, what more could we possibly have done to convince a jury of my innocence? How is this possible?
I was taken aback when they came back with a judgment of guilt. I felt that the defense had created serious doubt about all the other evidence, including the bite mark evidence.
During deliberation, the jury had requested 2 pieces of evidence: the mold of Kim's breast made at the autopsy and the cast of Ray's teeth.
Basically, the jurors, they took the molds finally, they passed them around and they fit the mold with the teeth.
When we used the molds, the teeth fit the marks that were on the breast mold. And I tried it myself. There was no doubt. I keep wondering about why we sat through all that, teaching us about hair and fibers and blood, and none of it mattered. If he bit her, he killed her.
While the jury found Ray guilty, the decision whether to accept that verdict rested with Judge James McDougall.
They heard all the evidence. They were 12 of 24 people that had reached that decision, but there just was a nagging feeling that we hadn't gotten the right person here.
Ray Cron had been found guilty a second time of killing Kim Ancona. But Judge James McDougall struggled over whether to accept the jury's decision.
Even though I disagreed with the verdict, it's not something I could easily just set aside. But that lingering doubt was enough to make me feel that I can't sentence this man to death.
Ultimately, Judge McDougall sentenced Ray to life in prison, but he also issued a remarkable statement.
He said, quote, "The court is left with a residual or lingering doubt about the clear identity of the killer. This is one of those cases that will haunt me for the rest of my life, wondering whether I have done the right thing."
For Judge McDougall to give Ray a life verdict as opposed to a death verdict was not something that was well received by the Maricopa County Attorney's Office. So for him to do anything more than that, I think he would have been run out of town and he would have lost his job.
Ray was sent to general population in the spring of 1996, where his former death sentence earned him respect. But all that changed one day when a television program came on the air.
I was in my room that day, and a guy knocked on the window and says, "Hey, you better check out Channel 4, you're on TV." I'm like, "What?" And I turned my TV on Channel 4, and here was Arrest and Trial.
Ray Cron, a 32-year-old postal worker.
And in that film, the two detectives say that when they got to Ray's red Corvette, they opened up the trunk and there were bloody sheets in there.
And we later found out through the crime lab investigation that the blood came back to Kim Ancona.
There was no blood traced back to Kim in his possession.
They got pictures of me running down the road. It said I was charged with sexual assault.
Based upon the evidence, Ray Cron wanted to have sex with Kim Ancona that night. He was just shaking. He was so nervous. He couldn't believe it.
Sexual assault ain't accepted in the prison, so even the people that had known me for about a year or so were now about to cut my throat just because of that episode there of making it sound like I had raped and assaulted this woman.
When they convicted Ray this time, it was clear to me that the justice system was not going to solve this case if we ever wanted to get Ray freed. It was a matter of now we're going to have to solve this case.
Ray's last hope lay with finding the real killer. To investigate, the defense brought on former homicide detective Thomas Streed.
One of the things that the police department was made aware of was the fact that a neighbor living across from the CBS lounge saw a Native American leaning against the wall of CBS lounge by himself during the early morning hours. He essentially wrote out a note to the police. He said, "The man you're looking for appears to be an American Indian."
There was one woman that knew Kim that was in the bar, and she identified an American Indian drinking in the bar that night that Kim Ancona had kicked out.
Kim and I were laughing at this one guy who was all westerned out, but then he had a pair of ugly tennis shoes on. He wanted another beer, and she said, "No, I'm cutting you off. You've had enough." That probably made him mad. I told Noel Levy that I believed that Ray Cron did not do this, and that the guy that was at the bar, I said, would give him all reason to do this because he got cut off. But Levy was cranky with me. He was set that Ray Cron did it, his teeth marks.
Detectives investigated Terry's tip without success. But by 1998, law enforcement was developing a new tool, a national DNA database called CODIS.
I glommed onto that as the Ray's salvation, that these databases are going to eventually get populated, and then we could put the profile into the database and find out who actually killed Kim Ancona.
By 2001, Ray's team believed CODIS was strong enough for a new round of tests. they filed motions for access to Kim Ancona's clothing.
I wanted to see all of her garments, all of her clothing, because when an individual is in the process of carrying out an assault on someone with an edged weapon, with a knife, their hand slips off of the grip over the blade. They accidentally cut themselves. So this individual's blood might have wound up on the victim's clothing.
We originally requested a DNA testing in October. It was granted by the judge, and we were told it would take 6 to 8 weeks. So November went by, December went by, January went by, and we still ain't heard no results. We're like, what's going on? And then it turned out that they actually had the test results done. They didn't like the results because it identified somebody else.
A DNA profile was uploaded into the CODIS National DNA Database. Whether the person that did the crime was in the database, that was a shot in the dark. But in the end, they got a hit towards a person named Ken Phillips.
Kenneth Phillips was a Hopi Indian that lived about 500 yards from the CBS Lounge. He was a hardcore drinker. He had a record of sexual assault.
Phillips was already in prison for sexual assault, and he matched the description given to police on the morning of the murder.
I called up Noel Levy and I said, you know, you have to release Ray Cron and you have to release him now. And he said, no, that's a tentative hit. That's just a mistake. It's a fluke.
With the prosecutor's office dragging their feet, Ray's forensic investigator, Thomas Streed, visited Phillips in prison.
We were seated at a table in the cafeteria, and I said, you must have felt absolutely horrible coming home that night, all covered with all of that blood.
Over the course of the interrogation, Phillips recalled an altercation with Kim Ancona, and later, waking up with blood on his hands.
After the conversation with him ended, we were convinced that he was absolutely, unequivocally, without any question whatsoever, the sole individual responsible for Kimberly Ancona's murder.
Streed's suspicions were confirmed when the hair and fingerprints found on the scene matched back to Kenneth Phillips.
And here's the great part. Kenneth Phillips does not have crooked teeth. Their entire theory that only someone with crooked teeth could have bit that woman on the breast as he killed her was wrong from the start.
On April 8, 2002, Ray received a phone call from his defense team.
My attorney, he said, Ray, how you doing today? I said, fine, just another day in paradise. He laughed. Then he said, well, what are you hungry for? You want seafood, Mexican food, steak, a beer? What would you like? I said, what are you talking about? I'll eat whatever's in the chow. He said, I just got off the phone with the prosecutor's office. They just got back from the judge's chambers. They're cutting the paperwork. You're coming home today. And of course, what did you just say? He said, roll up, Ray. It's all over. You're coming home.
I drove over to the prison in Arizona, and I could hear a big, clapping and yelling and so forth.
They're all jumping up down here. They had TV was on. It was saying about how I was being released, and they're all, still some emotional things happened that I still remember. But they're jumping up and down in their bed saying, go home, Ray Cron, go home, Ray Cron. They're all excited for me because they just seen on TV, it was just announced that I was being released.
As soon as I got the call that Ray was being released, I called my husband and Ray's younger brother, and the three of us drove straight through 27 hours to Phoenix. Oh man, it was like to see him standing on free ground and able to touch him and talk to him, and it was like this is what we've been waiting for, and now it finally happened. It was a dream.
Now, nothing's going to keep us away from Ray for as long as we want, and he can eat what he wants and go where he wants and wear what he wants and say what he wants, and it's going to be great.
I got a phone call from a friend, said, you need to turn on the TV right now. And I turned it on, and they were talking about letting him go. At first, I was in shock. Why? What's going on? And as I listened to the rest of the story, they said, based off of DNA evidence, and that is when it clicked. He really didn't do it.
During the trial, he seemed very cocky and confident, and that made me feel a lot of anger. I realized why he was like that, because he was innocent.
Kenneth Phillips eventually pleaded guilty to the murder of Kim Ancona. He was sentenced to 53 years in prison.
We owed it to Kim to find the man who really killed her, not to send an innocent man to prison. Kim deserves so much better. Her family deserves so much better.
I actually apologized to Ray. I wrote him. I told him that I'm very thankful that he was proven innocent, and then him losing 11 years of his life for something he didn't do. It was really heartbreaking. I felt guilty.
After spending over a decade in prison, Ray Cron became the 100th death row exoneree in the United States.
People started to question, how could a regular person be put on death row and convicted not once but twice based upon bite mark evidence?
And so bite mark analysis, is it a valuable crime-fighting tool or is it junk science? Ray Cron's story, I think what most people see and worry about is that there could be others like him that were convicted on this sort of science that got it wrong.
Ray's story was a horror story. This is a totally innocent guy who gets caught up in the egos and incompetence of people in Arizona and ends up losing 10 years of his life. It was a travesty of justice. I would hope people in Arizona had learned from the Ray Cron case, but I wouldn't bet my life on it.
I lost complete faith in the entire system. And that's when I started realizing and thinking, he's probably not the only one, and this has happened a lot.
If they can put me on death row, they can put anybody on death row. I didn't have a record. I'm not a monster. I'm a veteran. I work for the post office. And so I share my story with civilians, of people in law school, people in colleges, people in churches that one day might serve on a jury. You know, just make sure you got beyond reasonable doubt that they are guilty, that just because they were arrested doesn't mean they did something. If we kill them, we can't bring them back, and we found out we made a mistake. And we do make mistakes.